Good morning, everyone. Welcome. It's lovely to see all of you, and I am very excited to be back in person. My name's Tani Alvarez. For those of you who don't know me, I'm an attorney here at Verrill, and I'm the vice chair of the Employment and Labor Group. For those who aren't familiar with this series, who this is their first time joining us, prior to the pandemic, the Employment and Labor Group held a yearly day-long seminar that recapped all of the labor and employment news from the past year, and then trends that we wanted to look forward to in the year ahead. During the pandemic, we took every precaution to make sure our clients and the community stayed healthy. And as a result, we made our usual one-day seminar a year-long enjoyable activity with monthly virtual webinars. This is the first time in 3 years that we've been able to have in-person events again, and we couldn't be more thrilled to be meeting and seeing all of you in person. I know that some of us have had the opportunity to see each other in person prior to now. In most cases, that's not something anyone's excited about because I know time with Doug, with me, with Rob, with Liz, with Emily, with Beth, is not their favorite time. Although I think we have amazing, wonderful personalities. We're fun. We have good jokes. At the same time, I know there are people you'd prefer to be spending your time with. So we have a great program set up for you today. And if I can use the little clicker correctly. See, this is where we started a couple minutes early because they knew I was going to have clicker issues. Oh, yeah. There we go. So what are we going to talk about? We're going to start the day off with Emily Waddell. Put her little hand up. And Doug Courier. They're going to kick things off with legal and policy developments in labor law with Section 7. We're then going to turn to Liz Johnston, Peter Gore, and myself, and we're going to talk about changes in the judicial and legislative branch at work, Supreme Court and Maine legislative updates. Our third session will feature Beth Smith and Jeffrey Russell, and Jeff's going to be a new face for everyone that we're excited to introduce to you all. And they're going to be presenting on navigating employment practices, liability insurance, and workers' compensation. Say that one 4 times fast, and then talk to your agent about whether or not you have the correct insurance. And then finally, we're going to, my notes say, finally, but certainly not least, I will be presenting Doug Courier as he talks about discrimination at work, implicit bias, microaggressions, and code switching, with me providing support to him. So thank you all again for coming. And without further ado, please join me in welcoming Doug Courier and Emily Waddell.
Thank you. So if you look at the slide, you will see Rob Brooks' name up there. And Rob is going to be presenting today, but is under the weather. And so he just said, you know, I just don't think I can come here and start coughing and hacking and having people focused on whether or not they're getting my germs as opposed to taking in the information we wanted to share. So I will do my best to fill in for Rob. And I was, aggressively trying to learn the material. But then as I started to get into it, I realized this is the stuff we live with every day. So I think we'll be all right. So with that, let's get started. And let's see if I know. Yep, great. So basically, this is the outline for today's presentation. We're going to talk a little bit about 2022 labor trends. And this is unfortunately an area where there's some real news because it means that unions are gaining a lot of ground in terms of their organizing efforts. And there's been, a lot of pressure on employers in terms of understanding how it is to respond to a unionization effort because the rules of the game have changed. Second thing we're going to be talking a little bit about is, and we always do this when we do a presentation on the National Labor Relations Act, why is it relevant for those of you in the room who do not actually have a union? Because sometimes then someone's sitting there and saying, well, we don't have a union, so I can just check my email and focus on other things during this particular presentation. Then we're going to talk about some of the major developments that have taken place with the National Labor Relations Board in 2022. So that you have an understanding. This goes to the topic I was talking about in terms of the rules of the game have changed and not in favor of the employers. And then finally, we're going to talk about how the National Labor Relations Board, and this is a trend we're seeing more broadly, how these different government agencies are starting to communicate more so that when they see a problem, they have a method and means and intent to notify other agencies where they think that, this is something this other agency was going to be concerned about and want to pursue as well. And then we have a hypothetical that we can go over if we have enough time, and hopefully we will in fact have enough time. So with that.
Great. So like Doug mentioned, and can you guys hear me okay with the mic? Okay, good. So like Doug mentioned, labor was really everywhere in the media this last year. I don't know if you guys kind of noticed it or felt it as you were taking in the news or newspapers or what have you. But really the headlines were pretty consistent throughout the year. So nationally and locally, we saw headlines. First, nationally, we saw that Amazon had their first union be formed at their Staten Island warehouse. We also saw the NLRB and the CEO of Amazon kind of get into it. The NLRB basically claimed that the Amazon CEO went on TV and made some statements that were violations of the NLRA. He maintained that that was his right to make those statements. So that was kind of a dramatic thing to see in the news. Then we also saw Starbucks unionizing all over the country, which was pretty interesting, seeing as they hadn't really had a lot of union activity before this last year. We saw Railroad Workers United. While they don't fall under the NLRA, this was also notable because we had President Biden come in and avert a strike at the last minute. And you might recall that during the campaign, President Biden had said that he would be the most pro-labor president ever. And the railroad workers kind of felt a certain way about that after he averted that strike. We also, in the healthcare space, had a major nurses' strike in New York City. This one kind of carried into 2023, but was really revving up in 2022, hence why it's on the slide. But that resulted in 7,000 nurses walking off the job, and shortly thereafter, a deal was reached and they did return to work. So nationally, that's pretty remarkable, but locally, we also saw the same effects here in Maine specifically. So we had Bangor Daily News recognize the union at their recognize the union at Bangor Daily News by the parent company. And then we mentioned Starbucks. So we know that Starbucks in Maine did organize in Oldport, and Starbucks shortly thereafter closed that organization or location, excuse me. And then we saw Maine Med nurses win their first ever contract. So pretty remarkable that we have both national and local headlines. And I think if this was all we were seeing, just an increase in headlines, it would be interesting, but perhaps we could chalk it up to the media or to just more of an interest in kind of what's going on with unions. But as you'll see on the next slide, there are statistics to really back up these developments. So you'll see that the number of elections since 2021 have increased, and that's a 50% increase, which is pretty significant. We also are seeing that the percentage of union success in these elections is also increasing, up 11% from 2021. We also see that when unions are organizing now, it's not the traditional industries that we're used to. We're seeing colleges, universities, coffee shops, and dispensaries. These are kind of out of left field from what we would normally expect. And we also see that there's been an increase in strikes and different types of labor actions. And against all of that, so we're seeing increased strikes, increased unionization, and increased organizing. We also see that in a Gallup poll, more Americans approve of labor unions. So Suffice it to say, this is a really interesting backdrop that we're going into 2023 with. And, you know, there's a lot to kind of take in from this. But as Doug mentioned, you know, what if your organization doesn't have a union? Is this something that you should still be concerned with or paying attention to?
So we get a call, it's from a client. Big client basically says, you know, I am really frustrated because I gave one of my employees a nice raise and I told him to keep it confidential. And it turns out he didn't, but instead told some of his buddies about it. And so now I've got other employees that are coming to me complaining about the fact that, you know, Joe got a raise and we didn't. Why is that? We want a raise too. And then I've got a situation with another employee who is just causing all sorts of problems. He's constantly complaining about management. He's calling us names. He's telling some of his coworkers that, you know, we are really lousy and we're unfair and we can't be trusted. And this person is just a real troublemaker. And I just feel like, you know, the person's defaming us and there's got to be something that we can do. And the conversation that we have is, well, you know, there's this law, it's called the National Labor Relations Act, which protects the rights of employees to engage in concerted activity. And the response is, well, wait a second, I thought that relates to union activity. And we don't have a union, there's no talk of a union, and so I don't think that applies to us. And frankly, I would like to be able to tell this employee that I have a real problem with the fact that they disclosed the raise, even though I told them not to. And I'd like to tell this other employee that, you know, they got a bad attitude and they need to get their act together and that, you know, defaming management is not okay. And so the conversation we have is, well, actually, the National Labor Relations Act doesn't apply just to unions. In fact, if you look at the critical section, which is Section 7 of the National Labor Relations Act, you cannot even find the word union. And what it does is it protects the right of employees to engage in concerted activity. And concerted activity means employees, one or more employees, you know, banding together. I know you're thinking, how can one employee by themselves band together? But let's just start over. It involves two or more employees banding together, or one employee speaking on behalf of himself or herself and other employees about wages, hours of work, and other terms and conditions of employment. And with the National Labor Relations Board, which is very broad in its thinking, they extend that to protecting the right of employees to talk about compensation. So that employee who shared the fact that they got a pay raise, even though they were told that they're getting the raise, the understanding they would keep it confidential, doesn't matter. That's protected activity. If you disciplined or fired that employee for that action, that would be a violation of the National Labor Relations Act. And likewise, the law protects the right of employees to gripe about management, to complain about how management's unfair, to basically make, you know, demeaning and you might even say defamatory comments about management. And although it doesn't protect individual griping, you know, it's hard to say when is someone just sort of, you know, complaining about their own situation versus the circumstances for all employees. And so it's just important as you sit here to keep in mind a lot of the concerns that we talk about in the National Labor Relations Act apply to you, even though you may not have a union. Now, one of the good things is a lot of plaintiffs' lawyers, the National Labor Relations Act, it really isn't on their mind because they don't deal with traditional labor issues. So they may not think when they're working with a plaintiff employee to include that as one of the claims, but it's getting more and more used by plaintiffs' attorneys. And so it's just an area that you need to pay attention to. Is this me? Yeah, okay. We knew there'd be a little hiccups given that. All right. So the National Labor Relations Act, I mentioned in my introductory remarks, has been very aggressive in looking for ways to expand the ability of unions to organize and to protect the rights of employees to unionize if they want to do that. And you'll see at the bottom of this in the third bullet, there's this reference to new courses of action are borrowed from the failed PRO Act. Now, the PRO Act was in 2021, and that was a law that got through the House, failed in the Senate, and it stands for the idea of protect the rights to organize. And it had a number of different provisions that really would have benefited unions and employees in connection with this whole concept of union organizing. For example, one of the things that would have been in that law was a prohibition of employers to hold what's called a captive audience meeting. The law currently allows an employer to say to the employees, we want you to come down to the conference room. We're going to talk about unionization. And we're paying you. You work for us. We get control of your time. We want you to sit through this conversation. And that's an opportunity for the employer to share, truthfully, information about why a union action may not be in the best interest of the employees. And the unions don't like that because the employees get information which may change their mind about organizing. And so they have lobbied, and part of this bill was to, in fact, prohibit employers from doing that, communicating with their employees in that fashion. And there were other provisions in there as well. I won't go through them all since they didn't pass, but one of the things that we've seen is the National Labor Relations Board has said, well, you know what? We didn't get that done through a change in the law, but we can do that through our policy making. And so the general counsel, who is very pro-union, has been very aggressive in coming out with positions that effectively are trying to accomplish the same things that were set forth in the PRO Act that failed. And through the board itself, all right, so you have the general counsel, who is sort of their chief lawyer, and then you have the National Labor Relations Board, which has 5 members. And it's effectively, you've probably heard this before, it's a political body. So there's 2 employer representatives, there's 2 union representatives, and then whoever's president essentially gets to choose the 5th member, who tends to be the same political viewpoint of the president. So at this point, we have a Democratic president who has been very clear about his support for unions, and so the board is very much pro-union at this point in time. And one of the effects of that is that the law changes because it's a political body. So when a Republican's in place, these are the rules. And then when a Democrat's in place, the rules flip-flop, notwithstanding past precedent, and they're something that's very different. And so right now we're at a point in time where the National Labor Relations Board has come down with some decisions which have basically changed the law, even though there's been no actual change in the law by Congress, which supposedly is the one that is going to be able to say what the National Labor Relations Act really means.
So the first one we are going to take a look at is a memo from the General Counsel to the board. So as Doug mentioned, the General Counsel is really like a prosecutor of sorts at the NLRB. They're not making decisions on the cases, but they're advocating on behalf of the union or the employee when cases go before the board. So what this memo basically is saying is that the General Counsel is going to find an unfair labor practice charge, a presumptive unfair labor practice charge, where an employer's surveillance and management practices viewed as a whole would tend to interfere with or prevent a reasonable employee from engaging in activity provided by the act. So what this means as you go through their memo is that they've identified and are arguing that certain technologies that we have in the workplace could be used to identify protected activity under the act and penalize employees for engaging in that protected activity. So the technologies that they reference include wearable devices, cameras, GPS tracking devices, et cetera. So there's a whole lot there. And basically what this means is that they could potentially be looking at certain employers who are utilizing these technologies and basically find cases where they can argue that the employer didn't create an environment where the employees were safe from being penalized for engaging in activity. So, what's kind of crazy from our perspective as we look at this is all of these technologies serve a purpose other than identifying what employees are talking about or doing and trying to crack down on Section 7 activity. So, this is really just something to be mindful of. This isn't law yet, because as we said, the general counsel is more of a prosecutor, but this is really them kind of raising their hand and saying, in the new year, we're going to be looking for cases to bring to you, board, that we're going to be trying to advocate for this approach going forward. So really the takeaway here for you all is to inventory ways that your organization utilizes these technologies and be aware of any employee concerns or complaints. So what this doesn't mean is to look at your technologies and stop using them, because obviously these things are used for other purposes, but just to be aware if employees seem to have maybe misconceptions about how these things are used in the workplace, and use it as an education opportunity to explain why these technologies are used, what you use them for, and maybe just eliminate any kind of discussion about it being used for another purpose.
So let me give you a sense of this from a practical point of view. So I've been doing this for over 30 years, and I've handled, I can't tell you how many union campaigns. And we have a client that has operations in basically all 50 states. And one of their facilities is now being targeted by the Longshoremen Union. And we got a notice from the union's lawyer on Monday, basically saying, look, we believe that your client has violated the National Labor Relations Act by engaging in surveillance and by interrogating employees. And we will not bring a charge against you if you agree to be neutral. That is, to take no stance on whether or not the union should come in, and to keep completely quiet. That is, agreed not to provide any information to the employees about the pros and cons of having a union, basically to roll over and just let the union come in. And our response was, well, can you tell us who supposedly said what to whom and when? And because we are committed to complying with the law, and we have no idea what you're talking about. And their response was, all right, since that's your response, we're going to go ahead and file with a charge. So last evening at 5 o'clock, we get notice of the charge being filed with the National Labor Relations Board. It's for a facility in California. Not only are they bringing a charge saying that we think the employer has violated Section 7 of the National Labor Relations Act, we're going to actually ask the NLRB to go to and get an injunction, to go to court and to try to get a court order telling you that you cannot at any time in the future violate the National Labor Relations Act. Now, from where I'm sitting, having done this for years, I've never seen this happen before. And the only reason it's happening, and the only reason they would have the gall to sort of do this, is because of what we're talking about right here. Because they know that general counsel has a much broader view of what employers cannot do, which previously they've been able to do, and it hasn't been a problem, including the general counsel is trying to suggest that, these captive audience meetings and the use of email and the like is a form of, threats or intimidation or interrogation or surveillance. And so because of the position that we're seeing here, this union is now being super aggressive in the communication and the filing yesterday, because they knew 2 years ago they'd never get away with it, but now they actually have an opportunity to sort of really put hamstring and handcuffs on the employer in this particular case. I think this is you.
Sure. Yeah, so the next one we're going to talk about is Bexar County. So you can see up here in the first line, the case history. You'll notice that a lot of these cases that we're going to take a look at, they bounce back and forth depending on who's in charge at the NLRB. So if you notice the years, those are going to align, usually to different administrations in the White House. So basically the case here at a high level is that this involved a theater that didn't have like one person performing at the theater. It was a situation where different artists and performers would come and give performances for certain weekends or weeks or what have you. And long story short, there was a disagreement between the orchestra members for, I believe, a ballet There was a decision made that they were going to use pre-recorded music and not hire actual orchestra members to perform at the venue. So big disagreement, and the orchestra members come and they start to protest a weekend where the ballet was not performing. So a totally unrelated performance. And understandably, the venue was upset about that because it's not, you know, the most enjoyable experience for guests to have to walk through a picket line to go spend their evening at the theater. And really what ended up happening here is the board held, going back to a prior decision in New York Hotel and Casino, that now that property owners cannot exclude off-duty contractor employees engaging in Section 7 activity in the absence of evidence that those activities significantly interfere with the use of that property. So this standard is more generous than generous towards unions than the past standard, which was harsher for unions and kind of required balance more in the favor of the property owner's interest. And really, this effectively minimizes property owners' interest in restricting Section 7 activity, even though it might feel unrelated to kind of what's happening there in the moment. So, you know, here, what we would advise is if you are in a situation where this could potentially be relevant for your business, having a clear non-solicitation policy restricting the time and place of demonstrations is important. And what becomes really important here is making sure that it's applied equally to union and non-union demonstrations. So the next one here is, oh yeah. Yes.
What's the correlation between the NLRB and the correlation between those two? The NLRB debate
And so those cameras and trucks are required by, what would you reference it? That requires those cameras and the like. Yeah, and so you can have them, and then the question just is, the National Labor Relations Board would say, well, is the employer abusing the use of those cameras? So it wouldn't be like the board would come in and say, oh, you know, we understand this law tells you have to have them, but we feel they might be misused, so you can't. They would not do that. What they would do is ask the question of, all right, we understand you have to have them and you can have them, but you can only use them for that purpose. And what we want to know is if you're trying to use it for some other purpose, some wrongful purpose that violates. Yep. Yeah, so I think the National Relations Board would ask two questions. One is, did you not have it facing the cab? And then all of a sudden you hear there's union activity, so suddenly turn on the cab facing camera. That would be a problem. And then the second thing I could see the board, because they can be super aggressive, is to say, all right, we understand you have to have the cameras, and we understand you've always had the cab camera on, but now there's this union thing going on. You know, we don't really understand why you need to have it on, and we think you're using it for surveillance, so we think it's a problem that you're still having it on. So I could see them doing that.
So the next one we're going to look at is American Steel Construction, and this concerns micro units. So this would normally come up if an employer was facing a unionization campaign. And as you'll see here too, you can see that the cases kind of bounce back and forth depending on who's in office. And this was also proposed in the PRO Act. So this is not a new topic by any means. And really this comes up when a union comes forward and says, you know, we're going to hold an election. We've been talking to your employees. We think that the unit should be, you know, these 6 employees, say. It seems kind of counterintuitive because generally you would think that the employer might not be excited about the fact that their employees are unionizing in most cases. But sometimes for strategic reasons, the employer wants to say, you know, hey, I understand that you think this unit is 6 employees. Really, we have a group of workers over here who are doing the same type of work, maybe in a different location or at a different time. And we want them to be included in this proposed unit. And the reason why you would do that is potentially the union's going to come forward with the strongest unit that they can. And maybe those 6 employees that they've already talked to, they know they're going to vote for the union. But you as the employer might think, hey, if we bring in these other 10 employees, we don't know what way they're going to go. And maybe our chances are different in winning in an election if we increase our numbers. So what the case did here is it reverts to an Obama era rule where employers seeking to enlarge the scope of the petitioned for bargaining unit have to demonstrate that the excluded employees share an overwhelming community of interests with the group that the union seeks to represent. So there's a lot of factors that they look to here, but really the punchline here is compared to the cases listed previously, Boeing and PCC structurals, this is a harder test for the employer to meet, which could impact their ability to increase the scope of the voting population in a representation election. So here, you know, the takeaway is really to understand your job classifications and be able to differentiate one class from the other. And, you know, this is good to know all the time, but especially in these situations, it's just nice to have a good understanding of what groups are similar, what groups are different, and kind of what are your arguments possibly if you're ever in this situation.
To give you an understanding of this from a practical point of view, 20 years ago, we represented a company called Maine Armored Car and Carrier Service, which is now defunct, so I can talk about it. And they had 2 classes of drivers. One was the quintessential armored car, you know, exactly what you would envision when you think about an armored car. And then they had which was like a messenger service where they would safely transport important stuff, but it wouldn't be in an armored car. And they had like 30 armored car drivers and they had like 80 messengers. And the union tried to organize the 30 armored car drivers, and they had about 20 of the armored car drivers had signed authorization cards saying you want this union. And that's important because in order to go forward with the union election, you have to show an interest of at least 30% of the proposed bargaining unit. And so 20 out of 30 is, you know, 2/3. And so they had sufficient showing. We went in and argued, no, that's not an appropriate bargaining unit. The appropriate bargaining unit is all of the employees, the messengers and the armored car drivers. And we had a trial before the National Labor Relations Board Regional Director Office in Boston, and they ruled in our favor. And they said that the bargaining unit, the only one that is appropriate here is both groups, which goes from 30 people to like 110 people, and 20 out of 110 is less than 30%. So the election didn't go forward and that they had no union. With this change here in this decision, we would have, that result would not have happened. We would have lost that. They would have said, no, totally fine. You can have a smaller unit. We're going to let it go forward, and the union would have gotten in. So it has a really significant, just a practical sense of how things really are different. So you call me up and you say, we're getting sued for discrimination. And if the employee wins, what are the remedies? And I would say, well, you know, it's actual damages. It might be, you know, future damages. But there's also consequential damages, emotional distress, pain and suffering, things like that. There's also punitive damages, also attorney's fees. And so when you tally it all up, it can be quite significant. Now you call me up and you say, I've got this employee who's suing me under the National Labor Relations Act, former employee, because we terminated their employment. He's claiming it's in retaliation for engaged in union activities. You know, what's my potential exposure? And what I would have said a year ago was, well, if they win, they get, you know, potentially get their job back and they get back pay. No consequential damages, no punitive damages, no attorney's fees, a lot less at stake. The PRO Act that I talked about that they were trying to pass was going to change that and to allow an award of additional damages. But as I also mentioned, the PRO Act didn't get through. So I also mentioned that the General Counsel has aggressively, and the National Labor Relations Board has aggressively tried to, you know, put in place the same type of protections that the PRO Act was trying to accomplish. And this is a great example, because in this decision right here, what the National Labor Relations Board said is, we view the remedies provision in the National Labor Relations Act to make the employee whole. And so we now think, even though it's been completely different for the past, fill in the blank, 50, 60, 70 years, that what the act really means is that damages need to, in order to make someone whole, need to go beyond just providing back pay. So we are going to look at whatever else we think might be relevant to make the person whole. So let's say you terminated their employment and they didn't have the money coming in from their wages, and therefore they fell behind on their mortgage, and so they had to pay some additional interest and penalties, or they didn't make a tax payment and they incurred some additional costs. We're going to impose those as consequential damages as well, because that's necessary to make the employee whole. And they've taken it so far as to say, if because of there's things you would have received at work that are no longer available to you, and therefore you have to pay for it for yourself, we're going to include that as well. And so one example was the cost of baby formula, because the individual would lose the access to the workplace lactation room. So the long and short of it is, we just need to understand that the rules have changed, and if you're facing an unfair labor practice charge in connection with terminating someone's employment, that they're now going to pursue remedies that they wouldn't have a year ago, 5 years ago, or 50 years ago.
So this next one that we're going to talk about would come up in the context of an unfair labor practice charge. And this would be, where an employer receives notice that a employee or a group of employees has filed a charge against them at the NLRB. Maybe you kind of know what it's about. Maybe it's coming totally out of left field, and you might decide that you want to conduct an investigation to learn more about the charge. So Sunbelt Rentals is reintroducing a standard that was first articulated in 1964. And what it does is it sets forth some rules about how you're going to communicate with your employees if you're talking to them about an existing unfair labor practice charge. So, first it talks about the things that you have to tell the employee. So the purpose of the questioning, assuring them that they're not going to be retaliated against for their answers as it relates to the questioning. And then you also have to obtain their participation on a voluntary basis. There's also rules about the context in which the questioning has to take place. So it has to be in an environment that's free from employer hostility to union organization. It can't be coercive. And you can't ask about things that exceed kind of like the reasonable bounds of what you're looking into as it relates to the union and their involvement. So, it's a lot to kind of take in. It is worth noting that there are 5 circuit courts of appeal that have refused to apply this standard, but it's still around at the board. So really, the takeaway here is, this is kind of a very specific situation, but if you ever find yourself in this type of a situation, it's just important to know that this standard exists. And this is likely something that you're going to want to make sure that you're aware of and implementing in those interviews.
So think about it, as an employer, and you've got something going on that's really important to you, and you have employees who have knowledge, employees who you're paying and who are supposed to have some element of loyalty to you, and you go to them and say, I would like the information you have. I'm only asking for the truth. You won't be retaliated against. Your expectation is that they're going to cooperate and provide you with that information. And this is basically saying that you have to tell them that they can choose not to. They can say, yeah, you know what? Actually, I'd prefer not to. And the board's saying then you have to respect that, which, if you're not going to retaliate and all you're asking for is the truth, then it really feels as though that should not be a problem. But that's the world we're faced with. And we're going to, with this unfair labor practice charge that came in last night, we're going to go to California and we're going to sit down with employees and we're going to go through that list. And, there's a potential that they might all say to us, no, we're not going to provide you any information, in which case, did I just knock something over? In which case we will, get back on the plane and come home. But hopefully our wonderful people skills will encourage them to share with us. So I had referenced this before, and I think it's important to note that this goes beyond just this question of the National Labor Relations Board. But we're finding more and more government agencies are cooperating with each other. And so that if, the Department of Labor, State Department of Labor comes in and does an audit and determines that you have misclassified some employees, they are more likely to, share that with workers' comp, unemployment than they would have in the past. But what we're seeing here is that the board is saying, look, if we discover something that raises a concern with how employers are working with their employees, then we're going to let other interested agencies know. So if we come in and we think that there's independent contractors who should be employees, we're going to let the Federal Department of Labor know, and they'll come in and they'll hold the employer accountable, because that's really consistent with our mission, is to make sure that employees are treated fairly, and if they're being misclassified, they're not being treated fairly. Same time, though, there's an emphasis on, if it's question of promoting the interests of the employees, protecting the employees, we may not, and likely will not, be as open to communicating with other agencies. And by that, I mean, for example, situation where they go in and they find out that some of the employees who are protected by the National Labor Relations Act are not authorized to work in the United States. And so presumably, if the government is concerned about enforcing the rules, that they would notify immigration that, look, we've got some people here who are basically not supposed to be here and working in the United States. But their position is, and I actually frankly understand this and personally I support it, is to basically say, we're not going to go contact immigration and say, hey, there's some employees here who are unionizing who shouldn't be here, and you should come in and process them out of the country. But I think the real takeaway is that it's part of sort of the idea of the board is aggressively trying to figure out additional ways to promote employee interests vis-a-vis employers. All right, so I think we have, how much time do we have, Ann? 5 minutes. Wow. Life of leisure.
Pretty good.
There
Yeah.
you go.
All right, so we have time to go through our hypothetical then. So I'll just read this out and we'll kind of maybe shout out the things that we think are coming up. But employer Widgets and Company is a non-union manufacturing employer. Widgets and Company is charged with an unfair labor practice by employee A, an undocumented immigrant. In his charge, employee A claims he and his coworkers tried to talk to their supervisor because they thought they should be getting overtime like other machine operators in the area. Widgets and Company told employee A and his friends that they were salaried employees. Then Widgets and Company reported employee A to DHS. Employee A had to break his lease and buy a plane ticket to fly back to his country of origin.
DHS being the Department of Homeland Security.
Thank you. So there's a lot there. I guess the first thing that I would point out is, the first line, the fact that the employer is a non-union manufacturing employer, not really relevant for the NLRA. We know that employees can still exercise their concerted rights under the act. We also, already talked about the coordination between federal agencies. So, when it comes to the fact that the employer here basically reports their employee, that's not good, obviously, and also possibly problematic from a retaliation standpoint, I would say. We also have possibly maybe some Fair Labor Standards Act concerns as it relates to the employee wanting to get overtime and looking at other companies about, the fact that they are getting overtime and they're not, though we'd need more facts to kind of figure that one out. And then we also run into possible consequential damages concerns with the purchase of a plane ticket.
And I think it's very likely that the board would take the position that but for the employee engaging in concerted activity, the employer would not have reported the employee. Even the employee is now out of the country, would still have rights that are actionable under the National Labor Relations Act. And as a sort of a related topic, I had a case recently where an employee was, a foreign national was terminated, filed a retaliation complaint with OSHA, but had to leave the country because they no longer were in status. And even though that person was out of the country, OSHA took up the case and pursued the claim. The good news is ultimately we prevailed on that, but notwithstanding the fact that the person was out of the country, no longer in status, didn't change the fact that the federal agency was going to aggressively pursue the case if they thought it had merit. So that ends our presentation. Thank you very much. If anyone has any quick questions, I think we have like 38 seconds left. And otherwise, I'll turn it over to the next presenter. Oh, that's questions, and which is Peter, Tawny, and Liz. All right, thank you.
So one of the great parts about us working through the pandemic was that at moments like this, when we unfortunately can't all be together, even though so many of us are here in person, unfortunately, some of our team members have other obligations in Augusta and in general in other locations throughout the state. So unfortunately, Peter Gore is unable to physically be present with us here, but he is still going to be present with us, but he's going to Zoom in. You can see his wonderful face right up here in the corner. Peter, do a little wave. I'm pointing at you. Wonderful. So Peter, Liz, and I are going to go through general changes in judicial and legislative branch as it relates to the employer-employee relationship. And we are really excited kind of for Peter to have joined our team this year at Main Street Solutions. And one of the things that I think we say to you very often is, hey, we don't make the law. We just help you interpret it and figure out how we can comply with it. The cool thing about what Peter and Main Street Solutions does is they affect and help work to make the laws and talk to legislators and lobby on behalf of our clients as to what will work and what won't work for them. So if after hearing what Peter has to say about what's pending in Augusta, you feel as though some of these things are going to be really bad for your business, I highly recommend reaching out to Peter after the presentation to have a larger dialogue about that. I always like to make sure people know what we're going to talk about so we don't get to the end of it and people say, Tawny, you didn't talk about any of the stuff I thought we were going to talk about. This allows people to zone out if they need to during the course of the next 45 minutes or generally kind of zone in. So we're going to talk about what's pending in Augusta in 2023. We're going to talk about what came out of Augusta in 2021 and 2022 that affects employers. We're going to do a general federal legal update, which is interesting because over the course of the last few years, we've been saying nothing's happening in Washington. And this time we have a bunch of stuff that's going on down there that we need to keep at top of mind. And then we're going to do a federal and state case law update. So with that whirlwind of where we're going, I'm going to turn it over to Peter to talk about what is pending in Augusta in 2023. The floor is yours, Peter.
Thank you very much, Tawny. So can everybody hear me down there? If you can, somebody raise their hand so I know I'm not talking to myself. Awesome. Wonderful. Next slide, please. So good morning, everybody. As Tawny said, my name is Peter Gore. I am here at the Maine State Chamber of Commerce's Leadership Summit at Sunday River. This evening, we're expecting the governor, the president of the Senate, the speaker of the House, a number of key legislators to talk about this legislative session and some of the policy decisions and directives that they'll be taking. Vero is a major sponsor of the Leadership Summit, so I'm excited to be here. I've participated in this in my position at the Chamber for many years, and it's always very interesting. So I'll certainly have some information to bring back to any of you if you're interested, but let's start with where we are right now. There were roughly 2,200 bill titles submitted for the first session. Just so you all know, a legislature meets for 2 years. And in the first session, any legislator can submit as much pieces of legislation as they want. So in this case, there are 186 members between the House and the Senate. Some chose to submit 0 pieces of legislation. Some chose to submit more than 100 pieces of legislation. So we're left with 2,200 titles. I've done this job for about 34 years, and that's the most I've seen in a single session. I've seen more than this much and a little more over 2 years, but not in one. And as my slide says, it is important to note that not every title becomes a bill, and not every bill ends up before a joint standing committee. But every bill that does appear before a joint standing committee gets a hearing. And it will be interesting to see how this institution is able to deal with this many bills in a short period of time. In most cases, when we did this last week, there were about 250 bills printed. As of this morning, there are 450 bills printed out of the 2,200 titles. Mostly what we have is just a brief description and a title. And even for printed bills, we're going through what's known as having to deal with concept drafts. And that's when a bill is printed and all you get is, for instance, I'm just going to throw this out there, an act to improve the working conditions of Maine workers. That's the bill title. When you see what the language actually looks like and what the lawmakers are proposing, it just says, this bill will improve the working conditions of Maine laborers. That's it. We don't really know how they intend to improve it. We just know that that's where they appear to be going. It's problematic. It's not very transparent. And what we haven't been able to figure out is it legislators taking that route, or is it the revisor's office that drafts all the bills? And we hope to get some clarity on that up here at the Leadership Summit tonight and tomorrow. So next slide, please. There are 2 bills that are printed and actually scheduled for public hearing. The first bill, LD 12, is the bill dealing with severance pay, and that's scheduled for a public hearing on Tuesday. Let me just very quickly touch base on this because I could talk about this stuff all day. But real quickly, Maine is a severance pay law. It affects what's known as covered entities, which as defined in the law are businesses with more than 100 employees at a single site, and they are industrial or commercial in nature. The severance pay law dates back to the 1960s. Its purpose was to protect communities in the event of a large employer closure, i.e. paper companies in small rural towns. And it requires the business, the closing of business that either at the time closed or relocated, to provide up to a week of severance pay for every year that the employee has worked, as long as you have worked at the place of business for more than 3 years. If you worked there less than 3 years, you weren't eligible. This bill proposes to do 2 things. It eliminates the definition of commercial and industrial, and thus any employer with more than 100 employees at a single site for 12 months is a covered entity for the purpose of severance. Second, it proposed to eliminate the 3-year requirement for eligibility. In other words, if you work there 3 weeks or 3 years, you're eligible for severance under the proposed change. And this is an administration bill. I did meet with the Commissioner of Labor, and I met with the Director of Bureau of Labor Standards, Mike Rowland. They have decided that they're going to go ahead with the elimination of commercial and industrial, but keep in place the 3-year requirement for eligibility. That public hearing is on Tuesday. On the 16th, LD 53 will be heard. That is a bill dealing with workers' comp. And as you can see by the title, it deals with workplace harassment and assault, and it proposes to remove intentional acts or omission from workers' compensation exclusions. As you all know, in Maine, we have what's called the grand bargain or the social contract, which means all employers in this state are required to pay for and maintain workers' compensation insurance. And that is the sole remedy or exclusive remedy in the event of a workplace injury. The employee is not entitled to sue the employer or bring a tort claim. This bill would remove that exclusive remedy provision and allow a injured worker to bring a tort claim against the employer and tort claims are uncapped in damages in the event of, and this says harassment and assault, but ultimately omissions can mean anything. Someone doesn't mop up a wet spot on the floor and somebody slips and falls. Is that an omission? You would argue that in court. This bill is scheduled for public hearing, as I said, Thursday, the 16th. I will be opposing it on behalf of the Maine State Chamber. It's a very problematic bill. We're trying to find out more information on it. But those are the two big bills that have been printed so far. We have language for and are scheduled for public hearing. Next slide, please. So very briefly, I want to go through some of the proposed ideas in the various committees of jurisdiction that I cover. In broad generalities, the following kind of bills have been proposed in the Health Coverage and Insurance and Financial Services Committee. Expansion of coverage for dependents. Right now, the law says 26. This would expand it to 27 or 30. Establish a public option. Maine passed legislation last year that allows the setup of a single payer system in Maine, provided 5 other states in New England similarly adopt that. Hasn't happened, no surprise. In certain circumstances, you would reduce or eliminate copays or cost sharing around certain medical procedures and also pharmaceuticals. Facility fees that are imposed by medical facilities on ratepayers, and then health insurance mandates. In Maine, we have over 36 mandates. That means services that are required by commercial carriers to offer, and employers therefore would have to offer them to their employees. You can see you have blood testing for PFAS, dental coverage for disabled adults, care of expected mothers in adoption cases, etc. All mandates need to be studied by the Bureau of Insurance for cost impact, and so regardless, a lot of these either won't make it or they'll be put off until next year when the Bureau can come back with a study. Next slide, please. Labor and housing. This is really where it's going to be difficult, I think, for employers this session. And again, I'm talking broad generalities because all we have is titles or concept drafts. Create a living wage, amend the minimum wage to eliminate indexing or alter indexing of minimum wage. The tipped wage issue, cash out of earned paid leave, amend the equal pay law, establishment of a training wage, and disclosure of salary ranges in job postings. I'll be interested to see what this one looks like. Next slide. Again, flexible work schedules. I'm coming to the conclusion that this is in response to employers bringing employees back into the workplace. And I had predicted I would see legislation like this. Overtime, we're going to deal with the overtime standard again and what constitutes a exempt employee for an hourly employee for the purposes of overtime. Bill of Rights for temporary workers. The elimination of employment at will. That bill has actually been printed, but it's a concept draft. It's LD 324. We know very little about it, except it clearly eliminates employment at will. Wage violations, that bill has also been printed. It's LD 373. There was a similar bill last session. I expect it's the same as this, but it's a concept draft. Employee freedom of speech, employee workplace surveillance, again, in response to employees working from home. Harassment and non-compete agreements and the elimination of non-competes. Unemployment insurance, and then FMLA. FMLA will be a marquee issue for this session for employers and the legislature. It's the establishment of a state paid FMLA proposal. There's been a commission that's been working on this for about 16 months. It's my understanding their report just went to the printer, but they are proposing up to 18 weeks of leave at a max of 120% of the state's average weekly wage, paid for by some combination of payroll taxes on employers and employees, impacting employers with 15 or more employees. Next slide. And then workers' comp. LD 53 exclusive remedy, comp coverage for temporary employees, employee liability, and then an increase in the workers' comp board operating assessment. As you all know, employers pay for the operation of the Maine Workers' Compensation Board as assessment on your premium. The biennial budget increases that from 13 million to 14.7 million, which means an increase in cost on all employers. I believe that's the last one of my slides, Tony, and I hope I didn't take up too much time, but I will hang around for questions.
That's great. And we'll turn it over to Liz from there.
Thanks, Tawny. So Peter had talked about the potential for paid family medical leave in Maine. So we just wanted to, given that, sort of briefly look at Massachusetts paid family medical leave, which has a system that's actually fairly similar to the one Peter was describing as being proposed here. So it's an employer and employee funded program. Oh, there we go. You can hear that. That's paid through employer-employee funded, and it provides paid medical leave for reasons similar to the FMLA. It does provide a longer paid leave period and similar job protections as FMLA for Massachusetts employees. The program's been in effect for a few years, paying benefits since 2021. Overall, we think it's been running fairly smoothly in our experience. But one aspect of it that is worth noting is that under that program, the employee really has the burden regarding submitting their application for leave to the state, submitting their certification for the need for leave to the state. And that's a little bit different than we've seen under the FMLA, where the employer is really tasked with a large part of those responsibilities for getting leave, as well as other paid leave programs. So given that shift in dynamic that puts that responsibility and that burden on the employee rather than the employer, we potentially see the issue for a miscommunication or discrepancies that come into play when employees end up needing to take leave. So lesson to be learned from that is that if you're operating in Massachusetts and have employees who are needing paid family medical leave, make sure to stay in close contact with them and keep those communication lines open to avoid any surprises down the road related to their leave. Couple updates. Oh, sorry, can we flip back? Thanks. Just a couple of quick updates for Massachusetts paid leave as well. There are a few changes to the figures for maximum weekly benefits, contribution rates, and minimum income thresholds to qualify. There also is a new poster available that you should post if you haven't already that provides notice of those changes for your employees. Lastly, on that, on that last slide, I just wanted to flag a quick proposed update to the Massachusetts system. This did not end up going into effect, but there was a proposal to allow employees to use other paid leave benefits on top of their paid family medical leave benefits when taking leave. So currently under the system, if you are an employee and you're receiving paid family medical leave, you will cap out at a certain maximum threshold, which might not be as much as you were previously earning. So the proposal was to allow people to stack other paid leave provided by the employer on top of that to get more closer to what they were earning originally. That was ultimately rejected, but something we might see more of potentially in 2023, and also just a signal to keep an eye out for other updates to paid family medical leave in the next couple of years. All right, now we're in Augusta. So there have been several changes to Maine law that will affect most, if not all of you. And one of those is related to non-disclosure agreements. So if your organization uses employment agreements, separation agreements, severance agreements, and even settlement agreements, you will want to be aware of this law. I'm sure many of you have heard in the past few years, states are passing various legislation that applies to non-disclosure provisions and non-disclosure agreements between employers and employees. And a lot of this was in the aftermath of the Me Too movement and the desire to provide employees additional protections to talk about unlawful employment discrimination that they may have been subject to. And 2022, Maine became the next in line for those states to pass protections for employees or restrictions on non-disclosure clauses and agreements that apply both to employment agreements entered into early in the onset of employment, as well as those near termination or termination agreements. A couple key provisions to be aware of. I won't go into every detail for this law, but again, if these types of agreements are being utilized in your workplace, you will want to check out the law and make sure that you are updating your agreements. But for your employment contracts and sort of those outside of employment agreements, you may not have a waiver of the right to discuss unlawful employment discrimination, sort of a preemptive restriction on discussing any type of unlawful employment discrimination, not limited to sex harassment or sex discrimination. And for separation, settlement, and severance agreements, there are several restrictions that apply here. One is a restriction on limiting the ability to communicate with a state agency, a federal agency that enforces discrimination laws. You cannot have a prohibition on participating in the legal process in state or federal court. And there's also a restriction on preventing disclosure of factual information related to a claim of unlawful employment discrimination unless certain criteria are met. So it's a little wordy, I know, trying to mirror the language of the statute as much as possible, but the bottom line is, if you want to have a restriction on those facts and circumstances that are leading to an employment discrimination claim, which you very well may want to if you're at the stage of a settlement, separation, or severance agreement, there are certain conditions that need to be met under the new law. There needs to be separate consideration for such a provision. Also needs to be a mutual provision. But those types of provisions are allowable under those conditions. Again, if you do utilize these types of agreements, it's worth taking a look to make sure that your clauses are in compliance with the new law. Another big update we saw this year is related to vacation pay and the payout of vacation pay on termination. So previously, employers of any size had the ability to decide whether or not they wanted to pay out accrued but unused vacation time on termination of employment. But under the new law, employers with 11 or more employees are required to pay out vacation when an employee leaves employment for any reason. And the key term here is vacation pay versus other terms like PTO and sick leave. And that will bring us to the next slide, actually, and I'll turn it back over to Tawny to talk about that distinction.
Yeah, so as Liz pointed out, the key term's vacation, and a lot of people think, well, what is vacation? And unsurprisingly to all of us, vacation is not defined in the statute itself, which doesn't provide us with much help for organizations that may have a bucket of leave that they call paid leave, a bucket of leave that they call PTO, a bucket of leave that they call anything but vacation. Okay, so we've reached out to the Department of Labor, and the Department of Labor has advised that if it's called PTO, it doesn't need to be paid out under the vacation pay statute. If you, as you're required, have earned paid leave, and your earned paid leave is called earned paid leave and it's in a separate bucket, then that does not have to be paid out. But recall when you were instituting your earned paid leave policy, some of you may have said, Tawny, we already provide vacation, so I'm not going to give a separate bucket of earned paid leave. Our vacation policy itself covers that. If you do not have a separate earned paid leave policy and you kind of tucked it in with your vacation policy and you call it a vacation policy, you now have to pay out everything. Okay. Now, if you have a bucket that's earned paid leave and you have a bucket that's PTO, you don't have to pay out the earned paid leave at the end of employment, and you don't have to pay out the PTO. So if I was going to give one tip right now, maybe we change the terminology and we don't call anything vacation pay. We just call it PTO, and then you don't have to pay it out at the end of employment. You potentially could if you wanted to, but you wouldn't statutorily be required to. If you have a bucket called sick leave is not vacation time. And sick leave is maybe different from your earned paid leave bucket, but that wouldn't have to be paid out at all. One thing that we are seeing when we're having this discussion with clients is a dialogue going back to earned paid leave and how that has to be instituted, which is different from how most people institute their paid leave program. The way in which earned paid leave has to be paid out is using a different metric or a different equation as to what the regular rate of pay is. It's not just the base rate of pay, but instead you have to look at the prior work week for your non-exempt employees to determine the rate of pay that is used for the earned paid leave that's taken in the following week. So if you are just paying at the base rate of pay for your earned paid leave for your non-exempt employees and not taking into account bonus and other increased payments during the course of the prior week, you definitely should be speaking to someone kind of after the program. No need to raise your hand now, so that we can discuss best practices moving forward. In addition to the laws we just talked
Hey,
about.
Tawny, can I add something to that discussion?
Absolutely.
Can we go back 2 slides for just a minute?
Yes.
So under the heading of more blame or more credit than one deserves, I'm the one that negotiated this on behalf of the business community with the legislature. And I just want to speak to 2 things. First of all, I made sure the language in the law that talked about pursuant to the employer's vacation policy was there, because it does give the employer some control, but it also requires some work on the part of the employers. And that's why you should have conversations with Tawny or Liz about this issue, because the legislature's intent on this was not to wrap up earned paid leave and not to wrap up paid time off into this payout requirement. And that's important. And as long as, if you opt to change your vacation pay to PTO, you no longer have to cash it out. And we made that clear to the legislature that that could happen, and it didn't really matter to them. They just were focused on what employers want to classify as vacation pay. So that's it. I'm sorry to interrupt.
No, thank you, Peter. And you likely saw in Peter's slides about some of that, the 2,200 bills and the concept draft potentially regarding one that requires payout of earned paid leave. So based off of the titles that have appeared in this session, it appears as though someone's going to attempt to make it that earned paid leave has to be paid out at cessation of employment, but that bill hasn't been printed, so we don't know what the language is. But if you go through some of the stuff that's pending based off of Peter's slides, you know, we're going to see a big evolution here over the course of the next year or 2 years as to what's paid out and what's not.
Yeah, and just a piece of trivia on the earned paid leave law that most folks don't know. When we were negotiating that and the governor had brought us all into the Blaine House to talk about it, one night she was working late and she literally went and got the statute books out of the law library and sat down and took a 16-page earned paid leave law and distilled it to a page and a half. And that's actually what became law. And the governor had made it clear at the time to people that she was not in favor of requiring employers to cash out earned paid leave. And I don't see her changing that position. Just FYI.
It's interesting as well, because for attorneys in the room who may have gotten headlines this morning, one of the big ones, and you guys are going to laugh that these are our headlines, but is that Illinois is considering, and they didn't call it first in the nation, but an interesting and creative new bill that would apply paid leave to individuals without regard to sickness status. And interestingly enough, I mean, that's what our earned paid leave law is. So we're now at a point where ours was the first in the nation, and we're seeing more and more states now who are attempting to adopt this paid leave provision that you don't have to be sick in order to take it. Other things that we want everyone to be mindful of, beginning of the year, increase in the minimum wage to $13.80. Recall that that is directly correlated to your exempt employees and how much money they are making. So make sure that your exempt employees are making above the threshold of that $13.80. Based off of the multiplier. We also have the Crown Act, and that protects against discrimination on a result of hair texture or hairstyle. And that Crown Act language was added to the Maine Human Rights Act. Additionally, and not in 2022, but earlier, we saw Gender identity as added to the Maine Human Rights Act, and family status as a protected category. Make sure that you update your EEO policies from that regard. And then recall in 2021, we saw the non-compete agreement statute going into effect, 26 MRSA 599-B, which requires that you cannot require an individual to sign a non-compete agreement if they don't make over 400% of the federal poverty limit. It's around 50,000, and that it only is effective 6 months from the date the agreement was signed, or 1 year of employment, whichever one is longer. So if an employee signs a non-compete agreement and a month later you terminate them, you don't have a non-compete agreement with that individual, even if they're making, $200,000 a year. So just be mindful of that. What are some other federal legal updates that we should have at top of mind? So, things that are going on in Washington. The FTC has proposed a non-compete ban. You're likely thinking, wait a second, Tani, didn't you just say that Maine already has a non-compete statute and a ban? Interestingly enough, if the FTC proposal goes through, it'll overrule all state laws in this respect. It provides right now, the draft that has been proposed is that non-competes are not permissible except as it relates to the sale of a business, right? So transfer of ownership, acquisition type arrangement where one entity buys another entity, and in part they don't want the old entity competing with the entity they just bought. There is contemplation of a provision that would say that if an individual has 25% or more of ownership, you could have a non-compete provision as to their employment agreement. However, think about 25%. Jeff Bezos doesn't have 25% of Amazon. He could arguably, if he was kicked out by other members of the team, could start a competing organization, right? There's some big issues there. There's some big issues for venture capital teams as to how this plays out as to their business model. There's a lot of legal discussion about whether or not the FTC actually has authority to create a law like this. Administrative agencies aren't really supposed to be making kind of whole sweeping laws to this regard. So we know we're going to see challenges to it in the same way that we saw challenges to OSHA's regulations over the course of the last 2 years. The FTC isn't the only organization that we're keeping at top of mind as it relates to non-competes. We also have heard rumors that in the coming months, we're going to see a similar ban on non-compete agreements from the National Labor Relations Board, specifically that they're going to argue that non-competes violate Section 7, which is the dialogue that Doug and Emily were having this morning. So you're going to see the National Labor Relations Board attempting to just pull as much as possible into that Section 7 provision, which of course applies to all organizations, not just the unionized ones. If you're currently using non-compete agreements, this is important because it should give you a better idea of what the environment is and the environment that we're going to be up against if you ask us to enforce it in front of a court of law. The courts are looking at these agency actions, what's reasonable, what's expected, what effect do non-competes have on the business environment, and those elements are going to be taken into account when determining whether or not to enforce these non-competes. Some of you are thinking to yourself, wait, Tani, you said it's not final yet, so I'll just enter into non-competes with my employees now, right? I like how you think. The problem, however, is this FTC rule says any non-compete agreements that are currently in place are void. So as soon as this takes effect, all that work that you did where you're like, I'll get around them, Tani, and I, so very much appreciate all that creativity. Don't put your effort towards that, put it towards something else. Because right now, the statutory language, it's not a statute, but right now the regulatory language is saying, even if it exists, we're not going to allow it to exist moving forward. You're likely thinking, Tani, you're running close on time and it looks like you got a bunch more to talk about. The interesting thing is the Pregnant Workers Fairness Act got a bunch of coverage. I don't mean to disappoint anyone. It's not really news, okay? The Pregnant Workers Fairness Act really says, hey, you know how you've been protecting pregnant workers under the ADA because pregnancy is a disability, and you've been providing them with accommodations based off of disabilities related to pregnancy? We're going to give it a really special name called the Pregnant Workers Fairness Act, and we're going to take all the rights you have under the ADA and put it under this. They're calling it the PWFA because we like acronyms so much and we just have the capacity to learn more. Everything that the ADA provides now also applies to the Pregnant Workers Fairness Act. So if you're sued under the ADA for pregnancy discrimination, you're likely going to be sued under the Pregnant Workers Fairness Act as well. So just continue to provide reasonable accommodations to your pregnant workers. That's kind of the start and the stop of a very long-winded sentence. With that, you're like, speak out act, Tani. Does that mean you stop speaking or you start speaking? But the interesting thing is I'm going to stop and Liz is going to start.
I will speak out on this one. So the Speak Out Act, this also got a lot of press. It was enacted December 7th, 2022. I'm just going to briefly touch on it though, because it actually doesn't do quite as much as it initially seemed like it does. It actually does less than Maine law does related to non-disclosure agreements. So what the law does is it restricts enforceability of non-disclosure and non-disparagement clauses that are agreed to between an employer and an employee before a dispute arises when the dispute involves sexual harassment and sexual assault. So what does that mean? Basically similar to Maine's law, it means that an employer can't enter into an agreement with an employee, like an employment agreement at the beginning of employment, that waives their right to discuss details about sexual harassment or sexual assault that happens later. And that's a really key point here, is that this applies to pre-dispute agreements. So if a claim is made, if a dispute arises and somebody brings forth allegations of sexual harassment or sexual assault, and you want to get into a settlement or a separation agreement or a severance agreement and have restrictions about the ability to disclose that information, this law does not affect your ability to do that because it only applies to pre-dispute agreements. It also doesn't apply to any agreements that were entered into before it was enacted on December 7th. So it will only be forward-facing. So again, it's relatively limited in practice, given that it does only apply to those pre-dispute agreements, but another reminder to check out your clauses and agreements if you have those in effect to make sure it's compliant.
And now we're going to jump to a case law update. So quickly, the Walsh case just came down earlier this year, which it's beginning of the year, so it was recent. It is touching on the FLSA administrative exemption standard. If your organization has consistently thrown people that they feel should be exempt and receive a salary into that administrative exception, this case is for you. Specifically, the First Circuit is saying, listen, when the organization is set up to provide services and the employees who are providing the service, let's say you're a consulting organization and your consultants, right, are providing the service that you advertise providing, that's not administratively exempt because the duties of that individual are not administrative in nature as it relates to the service that's being provided. Now, if you are in the finance department, if you're in the marketing department, right, those people are appropriately administratively exempt in most situations if they meet the duties requirement of having discretion over matters of significance. However, if you're in a consulting industry and all of your consultants consult, they are not going to be administratively exempt, okay, just because of the work they're doing for your third-party clients. So if you're in a service industry specifically, take a look at Walsh. Mundell versus Acadia Hospital was argued before the First Circuit on appeal in December. It's the first time we've taken a good look at the Maine Equal Pay Statute. The facts there were 4 pool psychologists. The male psychologists were making $90 and $95 an hour. The plaintiff was a woman. She was making $50 an hour. The hospital indicated that the rate differential was based off of fair market value of the individuals, which included the negotiation skills of one of the male psychologists at the time of hire. The question was whether or not the statute requires discriminatory intent or if an unjustified pay disparity plays a role. So we are waiting for a decision from the First Circuit as to the standard within the Maine Equal Pay Statute. However, you likely saw in Peter's slides that there will be pending legislation this session concerning changes to the Equal Pay Statute, which I think will be as a direct result of the Acadia Hospital Mundell case. Not employment law cases, but still ones we want to watch are Students for Fair Admission, be President and Fellows of Harvard College and University of North Carolina. That is a question of whether or not you can use race in admissions decisions. And I think that's going to play a large role in how we look at DEI moving forward from an employer standpoint. Another one that is just something that is not at top of minds, but I think is going to be big as we move into 2024 is the question of what an ultimate employment action is. And the case in question is Hamilton v. Dallas County. In this case, there are a bunch of prison officers, and the rule in Dallas County was male prison officers are entitled to 2 days off any days of the week. Female prison officers are entitled to 2 days off, but those 2 days can't be Saturday and Sunday. They could be Friday and Saturday, they could be Sunday and Monday, they could be Tuesday and Wednesday, it could be Monday and Friday, but they can't be Saturday and Sunday. The female prison officers went to the county and said, this isn't fair, why can't women? And they said, because you're women. That was the answer, that was the response. Interestingly enough, bad facts make bad case law. The Fifth Circuit said, yes, you can change and you can make sure that there's limitations on when paid leave can be taken based off of gender, because leave is not an ultimate employment decision. The only things that are ultimate employment decisions are hiring, firing, and raises, right? So those are more ultimate, but the time that someone's allowed to take off isn't an ultimate employment action. There is a split in the circuit. In Texas, this is permissible. In Maine, it would not be permissible. But what we're going to see is action towards the Supreme Court in the coming years. It'll probably be 2024, 2025 term, where we're going to try to get more clarity as to what an ultimate employment action is. And under Title VII, whether or not you truly can have a policy like that that doesn't apply to an ultimate employment decision. So again, bad facts, bad law. Two other things to keep in mind from a state law standpoint, Hanlon v. Broadreach, this case determined that from a whistleblowing standpoint, the action complained of has to be work related. You can't just complain about some activity that's completely unrelated to work and expect protection under the Whistleblower Protection Act. The second one, and this is the one I want everyone writing down because they're going to want to go back and they're going to want to talk to their payroll provider, Dorsey v. Northern Light Health. This was a wage payment statute, and what happened is an employee got scammed. They got an email saying, please go in and change your payroll password, and then pay, and they changed their password. The scammers got the password. They logged in. They changed the account in which the direct pay was to go to. Interestingly enough, the account they changed it to wasn't the employees, it was the scammers, okay? The employer, Northern Light Health, paid the individual their wages. The individual says, I didn't get paid. They said, yes, look, we paid. She says, that's not my bank account. They said, well, you must have changed it. She said, I didn't change it. The scammer changed it. The court found that Northern Light was responsible for repaying the amount that it improperly paid to the scammers, even though it wasn't Northern Light's fault that the individual became the victim of a scam. So what's the takeaway there? If your payroll processing program right now allows the individual to go in and make changes all by themselves, you need to have some type of secondary process in place to make sure that it was in fact the employee who did it and not a scammer, so that you are sure that it's the individual, that it's their bank account that you're going to be paying, because otherwise you're paying the employee twice, most likely, if you improperly pay a scammer the first time. Thank you all. We're going to take a quick break now. Liz and I and Peter's available right now. So if people have questions for Peter, I'm going to have him ask them now because he's going to jump off. But if you have ones for Liz and I'm going to ask for you to wait for the break. Okay, thank you, Peter.
Bye-bye.
We are moving on to navigating employment practice liability insurance and workers' compensation. And most of you, I hope, know and adore Beth Smith, right? If you know her, you adore her. That's really what it comes down to. But I'm super excited to introduce everyone to Jeff Russell, who's in our litigation group, but who also does a lot of employment litigation and specifically EPLI work. So I am excited to turn the microphone over. Everyone's like, Tawny, you never turn the microphone over. You just keep talking. But I'm turning it over to them. The stage is theirs for the next 45 minutes, and then I'm going to take the mic again.
Thank you, Tawny. Good morning, everybody. Can you hear me okay? Like Tawny said, my name is Jeff Russell. I'll be talking to you about, well, let's put it this way. I joined the firm last summer, and so this is my first labor and employment seminar. So I picked the most riveting, spellbinding topic I could possibly think of, employment practices, liability insurance, and then I will hand it over to Beth, who is an expert on workers' comp, and we'll have some good stories and anecdotes. So employment practices, liability insurance. I'm going to stick with the acronym EPLI here. I know there was discussion earlier of earned paid leave. That's also EPL. There's the English Premier League. That's EPL. I'll try to differentiate it by saying EPLI. And this is sort of a brief roadmap of where I'm headed. What is EPLI? What is EPLI not? What does it do for a business? And I'll have a few slides at the end of practical considerations for any business. What should you know about this? And I'm assuming there's a pretty wide variance in the audience here about familiarity with EPLI. Some people may have never heard of it. Some people may have a general awareness. Hopefully not too many of you have a deep familiarity. That would mean you've dealt with a lot of claims. But there will be some brief overview, and then I'll get into some more practical considerations as we go forward, and hopefully, give some food for thought about how to optimize and get the most out of this product. So the purpose and scope of EPLI. The basics here are that EPL policies provide insurance coverage, liability coverage for employers against employment-related claims that are made by employees. There are some exceptions there. We'll get into what types of claims are likely covered, what are likely not covered. But a takeaway here is that this is really not industry specific. Whether you're from a manufacturer, or a construction company, or a university, a hospital, if you have employees, this is something you may need to deal with. Some sobering statistics about employee-generated claims against employers. Just in the last couple decades, employee lawsuits overall have risen about 400% nationally. And for wrongful termination suits, something like 250% over the last 20 years. So there are certainly more claims being filed. And the average cost to settle one of these claims, now that is about $75,000. Now that probably, and I do believe that statistic includes the attorney's fees, the defense costs. However, the average amount awarded in a jury trial, if things go all the way, is more than $200,000, which does not include defense costs. So these can be real claims. And again, that's average. And this also does not just plague a certain type of employer. More than 40%, nearly half of these claims are brought against private employers with fewer than 100 employees. So whether you're small, whether you're big, this is a reality. And here's some additional data from the EEOC regarding types of charges they receive. You can see the top couple most common are retaliation, and then there's a number of different types of discrimination claims that are brought. But you can see the raw numbers here. These are not rare, especially here. This is 2020. These numbers continue to increase. So for scope of coverage of employment practices liability insurance, these policies typically cover allegations pertaining to any form of discrimination, retaliation, harassment, all the things that go with these things, wrongful termination, wrongful demotion, failure to promote. Sometimes there can even be industry-specific coverages. For example, if there's anybody from the higher education world, there can be coverage for failure to grant tenure. For professional organizations, there can be failure to grant partnership. In some types of claims, it really does depend on the policy. Some other types of claims that might be covered, again, depending on the language, is failure to hire, for a prospective employee. Perhaps even a third-party claim for negligent hiring or supervision. Those may be covered. Wrongful discipline, maybe even some employment-related defamation. Even wage and hour disputes can sometimes be covered. That's a bit of a tricky situation. Sometimes only defense costs and not indemnity are covered. Again, the point is to know what's in your policy. And some common situations that are not covered would be, obviously, Beth's world, workplace injuries, workers' compensation. That's a different part of the insurance world. Illegal acts, criminal actions and fines, are typically not covered. Intercompany business disputes, that's outside the realm of EPLI. Also claims that are arising outside of an employee's scope of work. Again, employment-related claims by employees is what we're talking about here. So if it's something with an employee on personal time, that's not likely covered. If it's some side venture they have with other employees, not likely covered. So what does an EPLI policy actually provide? Now, again, assuming a claim is within the scope of the policy, as with any liability insurance, EPLI would cover the costs of defending, litigating, and resolving a claim. So typically that would be defense costs, pay for a defense lawyer. If there is an adverse judgment, they would pay for that award. And also, typically, again, if a claim is covered, the EPLI carrier would be driving the bus in terms of settlement negotiations, settlement payment. Most people in the room are aware of the rise of things like mediation, alternative dispute resolution. Most claims don't go to trial. Most claims settle or get resolved one way or another. So if you do have a covered claim, I would expect the carrier to be heavily involved in that, if not handling that. And just a note that obviously if there's a deductible or a self-insured retention, that can complicate that picture a little bit. So for the next few, my final few slides, I'm going to talk about a few different areas of practical considerations for businesses and organizations to think about, to know what you have, and to maybe go back and audit what you have. And so I'll call them by chapter here. Chapter 1 is policy limits considerations. So, it sounds kind of like a duh issue. Do you have enough insurance coverage? It's not as simple as it may sound. I have a little bit of an excerpt here from an EPLI declarations page. You can see it lays out the coverage period, 1 year, the limit of liability. So that's the amount of coverage, $100,000, $10,000 deductible. So how do you know if you have enough coverage under your EPL policy? Now, typically, most policies range from 100,000 in coverage. This is the very low end, and I'll explain why in a moment. Usually, I think the bell curve is probably 100,000 up to $1 million. Now, obviously, if there's a number of different entities or affiliates or associated businesses that are all under the same policy, you may want more coverage. If policy limits are shared with other types of coverage, like D&O, you might want more coverage. But sometimes that limit can be a little bit illusory. Like if we look at this excerpt here on that second row down, the $100,000 limit, if you look to the right, it says that's the aggregate for all, quote, loss combined, which includes defense costs. So this is actually what's called a shrinking limits or an eroding limits policy, meaning, yes, you have $100,000, but if a lawyer eats up 55,000 of it just to get to the claim to the place where it can settle, or to get enough information where you really know what's going on, there's not much negotiation purchasing power left on that policy. And so, make sure you have the amount of coverage that you really need here. I would recommend, auditing your business's history of claims, what claims resolved for, what adverse judgments were. This all goes into figuring out whether you have enough. And also certain types of coverages might have sublimits underneath. Let's say you have $1 million in aggregate, but there may be a sublimit for a certain type, like a wage and hour defense or a negligent hiring claim. Again, don't just assume that the actual insurance limit is really there and available to resolve every type of claim. And a note from my litigation experience is that if you don't have sufficient EPL coverage, obviously that can create a sticky situation where the business could be liable itself, but you are not typically going to be able to hold an insurance agent responsible for not getting you enough coverage. That's a misconception. Many people think, oh, it's my insurance agent, they're helping me out, or it's my business's agent, they're helping the business out. The insurance agent is the agent for the insurance carrier. They help the insurance carrier get new clients, bind new policies. They do not owe duties to policyholders to get them, quote unquote, high enough coverage. And so you may be able to be successful in holding an agent accountable if it turns out you don't have enough coverage. If you did ask them for a certain amount and they failed to get that for you, the law draws a distinction between that situation and them just having a duty to advise you about how much to get to begin with. And at least under Maine law, you will not be successful if you try to argue that. Chapter 2 of practical considerations, policy definitions. As with any insurance policy, the devil's in the details. The language is closely scrutinized when there are disputes over it. So I've selected 3 specific buzz terms here to briefly touch on. The policy definition of employee sounds simple, not so simple. That might include different types of employees. Does it include part-time employees, leased workers, seasonal employees, part-time laborers? Depending on your business, there may be all sorts of different types of considerations here. Does it include independent contractors? EPL can sometimes do that. Does it provide coverage for prospective employees, people who aren't actually employees yet, applicants? These considerations are relevant for failure to hire or discrimination type situations. The second one I've listed here is a definition of claim. Now, I'll touch on this again in a moment, but what is a claim? What triggers an obligation to report to a carrier that you have received a claim? Does an oral report to HR count as a claim? We all know that lots of these types of cases start with something like that. And again, I'll touch on that a little bit more in a moment. The third definition here, employment practices violation. That's really the heart of the EPL policy. What alleged employment practices violations are covered by the policy. If you have an EPL policy, I would recommend looking at the definition section under the employment practices violation to really have an understanding of the scope of your policy. I mentioned the failure to grant tenure example a few moments ago. If your policy is going to cover something like that, the first place I would look to determine whether that's the case is the definition of employment practices violation. This is typically a defined term, and again, a good place to look. So, Chapter 3 of practical considerations, reporting procedures. Now, this is obviously very, very important. If you take one thing away from my remarks today, it would probably be this slide. When informed of a claim, any policyholder of a liability insurance policy is obligated to report that claim to the carrier. And there are some different considerations and requirements that go along with that. The first one I've listed here is timing requirements. So, okay, I have to report a claim. When do I have to do that? How quickly do I have to do that? Typically, EPL policies have language saying that you need to report it as soon as is practicable. Now, I don't know what that means. Maybe you do. I certainly don't. Sometimes it'll say as soon as is practicable, but in no event later than 60 days past the end of the policy period. Okay, don't do it on day 59 after the end of the policy period. This is still, you are under an obligation to report timely. You're under an obligation to cooperate. It's part of the insurance contract. Untimely notice can certainly mean denial of coverage. Some policies even require that a claim be reported within the same policy year as the claim is made. So, understand these things and be proactive here. I did mention earlier there can be some gray areas about when our reporting obligations triggered. I mentioned the potential of an oral report to HR. Okay, that's a pretty common example. What about if an employer knows that an employee has hired an attorney to look into things? Is that something that would trigger a reporting obligation to a carrier? What if an employee doesn't necessarily file any claim, but asks the employer to agree to a tolling agreement to extend the period in which they could file a claim? These things are all things to think about. Most EPL policies require, have their triggering obligation happen after either a so-called suit, like the filing of a claim, administrative charge or lawsuit, or some sort of demand for payment. Usually those are the triggering events. However, again, some policies say written demand, some don't. Now that can be the difference between having coverage or losing coverage. The third bullet point here, notice of potential claims. Some policies do allow for a little bit of a Goldilocks zone, a middle ground where you don't know if something should be reported. You can say to the carrier, well, we've been told this. I don't know if this really triggers anything, but I want to make sure that that reporting obligation is checked. Sometimes also called a notice of circumstance. Basically, the idea is ensure proper reporting, particularly where you're being made aware of conduct or a potential claim, and that might not mature into a more formal claim until a different year. And finally, when in doubt, report. Right? Hopefully that's obvious by now. So don't get cute with this stuff. Let's give an example. So say an employer receives an administrative charge for Maine Human Rights Commission for some sort of discrimination allegation, and the employer thinks it's defensible, doesn't notify the carrier, just wants to defend it itself. goes through the commission process goes well. There's no finding of wrongdoing or anything. It's now the following year. The employee gets a new and better plaintiff's lawyer, and they file an actual lawsuit in court. Okay, the employer receives that, goes to the carrier and says, hey, we got this new filing. This is it's a new lawsuit. Please assign a defense lawyer. Please cover this. So how many people here, raise your hand if you think the insurance carrier is going to treat that subsequent lawsuit as a new claim? I may have given it away with how I asked the question, but that's okay. I want you to get the takeaway. So that's not a new claim. The original claim was the one to report. What I would say is EPLI, you ain't got no alibi, coverage denied. Sorry, that was terrible. I won't do that again. Basically, the takeaway is when in doubt, report. Chapter 4 of practical considerations, and I'm talking fast because I tend to run long and I don't want to step on Beth too much here. But if you have questions afterward, please approach. Losses that are actually paid by EPLI, again, in the event of a covered claim. The classic stuff that's covered would be compensatory damages, damages that are to compensate an employee for whatever the alleged improper employment practice was, emotional distress, et cetera, and wage replacement, front pay, back pay. Punitive damages often can be covered. I think more often than not, I have seen EPLI cover punitive damages, but it may not be, so it could be excluded. Things that are likely not covered, again, things like civil fines or penalties, criminal fines or penalties, severance pay, not something that's covered, property damage, things that are under other areas of insurance, data breaches, cybersecurity, that's not EPLI. Chapter 5 of practical considerations. This is just a brief note on standalone EPLI policies versus endorsements or add-ons to other types of policies. Now, sometimes a D&O policy, directors and officers might have an EPLI endorsement on it, or a general liability policy or commercial general liability might have an add-on that gives some EPL coverage. The only reason I'm bringing this up, and again, this is policy dependent, just like everything I'm saying, except for don't wait to report, is that often in my experience, I've seen that EPL endorsements or add-ons might not have the same breadth of coverage as standalone policies. So again, it's just something to look back, when you're doing the internal audit to see whether you have the right coverage here. If you have an endorsement, just be, 1 degree a little bit more vigilant about looking into the level of coverage. Chapter 6 of practical considerations. These are a few selected policy terms and conditions that I've flagged that you might want to be aware of. Anybody who's dealt with insurance, liability insurance before probably knows the distinction between a claims made policy and an occurrence policy. This basically just refers to, okay, so a claim, underlying events happen in a certain year, and then a claim is made in a later year. Which policy year should respond? And claims made policies, that's the classic, typical type of policy in the EPL world. Normally, so that would mean that whatever policy is in effect when the claim is made is the one that responds to the policy, as opposed to an occurrence policy, which is more like, your classic auto accident or, stuff like that. I've mentioned prior acts coverage here. Basically, if events occur in 1 year and then it's a claims made policy and then a claim is made in a subsequent year, you just want to make sure that there's not a gap here based on how the policy is set up. Consent to settle clause. So again, if a carrier responds and says there is coverage, are they required to get the policyholders, the insured's consent before resolving a claim? This typically is not required. This typically is not a part of EPL policies. It's more common in, I've seen it a lot in medical malpractice policies and other types of things like that. It can exist though, and so it's good to know what the parameters are of how claims might be resolved. And again, this also can be affected by whether there's a deductible or a self-insured retention. There may be certain requirements that go along with that before the carrier can settle something out from under an insured. And I've already mentioned this a couple times, the shrinking or eroding limits policies versus separate defense costs. Just know whether the coverage you think you have is actually the amount that you do have. Finally, Chapter 7, some common exclusions to be aware of. And when I say exclusion, again, anybody who's dealt with insurance before knows there may be something that on first blush would appear to fall within the parameters of coverage, but then there's specific language in the policy, a section titled exclusions, which does exactly what it sounds like. It excludes, it carves out certain situations from what otherwise would be covered. Prior notice, that's a big one. That's, again, very important in any claims made situation. You know, if a claim arises out of any allegedly wrongful act that happened or arose before the coverage period, you know, the carrier could easily say, you were supposed to tell us during that coverage period, report. You know, that's just part and parcel of the claims made insurance paradigm. Breach of contract and contractual liability is typically carved out of EPL policies. Bodily injury, that's an interesting one. There are typically bodily injury exclusions. Again, we've already spoken about workplace injuries being a workers' comp issue, but you know, some covered claims like discrimination or harassment do include compensatory damages for things like emotional distress. And in the world of insurance law, there is some overlap between emotional distress and bodily injury. And so I would seek either a clarification, if not a carve out, from your carrier as to, you know, what you wouldn't want is for there to be a bodily injury exclusion, you get a discrimination claim, and they say that they're not going to pay the portion of it that is compensatory damages for emotional distress. You would just want to clarify that the existence of that exclusion does not eat into otherwise covered claims. Again, property damage, labor disputes are often excluded. And finally, things like statutory violations, OSHA, Fair Labor Standards Act, stuff like that. There may be able to be coverage purchased, but it's not typically part of the initial menu. So with that, I will conclude my portion of insurance hour.
Can I have the clicker?
Yes. Do you want to switch with me? Or?
No, I'm okay. You guys can hear me okay here, can't you? All right. So quick shift to the crazy world of workers' comp. Believe it or not, sometimes there will be claims that arise in the world of workers' comp that may actually be covered under EPLI, not workers' comp. And I'm not sure if all of you knew that before, but if you don't remember anything else, it's important. You should check if you have a claim and see if you have EPLI coverage, see if it covers it. These three pop to the top of my mind. Discrimination may be covered by EPLI. It absolutely will not be covered by workers' comp insurance because they consider that to be an intentional act and they won't cover that kind of thing. Same with harassment, that sort of thing. So you could end up having a defense attorney hired by your EPLI coverage and a defense attorney from your workers' comp people, and you need to make sure all of you people are talking and agreeing on strategy. So that if that happens, it's important to get good guidance. Another one would be obviously the intentional injury, or I think that workers' comp has a provision that you get a defense as an employer that if it was an intentional injury or intoxicated employee, that's a defense under the Workers' Compensation Act. It's not necessarily something that EPLI might cover, but they might. So it's worth asking. The famous case where was the two meat cutters, and one of the meat cutters was responsible for cleaning the area, the room they worked in. The other meat cutter thought it'd be wicked funny at the end of the shift to start chucking meat at the wall. So the first one who had to clean it gave him a little poke with a knife, and that was considered intentional because he purposely poked him with a knife. So that ended up being a defense. Yeah, it's a great case, only in Maine, right? And then for the loaned employee can obviously bring a work comp claim against their actual employer. So it would be whoever loans them out, but they might also have an ability, as you guys probably all know, a third-party action against the employer for whom they were working at the time. And for that employer, that might be covered by EPLI because it's not going to be covered by that person. The second employer's workers' compensation will not cover that. So just keep that in the front of your mind and ask the questions. There is no penalty for being the best friend of your EPLI person, right? Just call them all the time and let them tell you, no, that's not covered. Stop calling me, you're harassing. But anyway, it's better to call and report than to find out that you blew it.
That kind of harassment won't be covered.
Yeah, exactly. So just promptly report thorough investigation. This kind of goes without saying, I'm sure, because we say this to you guys all the time. But there are some things that you want to think about if it's a situation that's going to be EPLI, and so not in the workers' comp world where we know our investigations, we have our forms, the whole 9 yards. One of the considerations you may have is, do you want to bring in an outside attorney to conduct that investigation, to potentially cloak it with attorney-client privilege, because they may be uncovering stuff you don't want out there on the street, right? The second consideration I always ask you to think about is, do you really want a written report, or would you prefer an oral report? Again, for the same reasons, not to be too cute by half, but if it's not written down, the guy walking out the trash can't read about it, right? So those are the two big things. And then when you are thinking about a release, be it an EPLI side or workers' comp, think about whether we're going to get a full release. And this is just a plug to remind you all that a workers' compensation claim is not settled until it's approved by an administrative law judge in the state of Maine. And that's very similar in neighboring states if you do anything. So while on the EPLI side, you could go to a mediation, you could negotiate a settlement and have it done right there. If you're at that and your defense attorney isn't bright enough to say, okay, and we're also going to go present this to the work comp board, just kick them under the table and then go do it, okay? Now we're going to talk, I'm going to make a little shift, a little pivot away from the EPLI and workers' comp thing, and just talk to you a little bit about what 2022 looked like from a legal standpoint at the law court and at the appellate division. Very interestingly, there were no cases. So back up for a second. Our Supreme Court, sitting as the law court, hate workers' comp, just hate it. And there's only one justice, Justice Jobber, who Rob and I grew up with, and his little boy Jojo was my brother's best friend, because this is Maine. That's how it works. He was a plaintiff attorney. So how do you think those cases are going to go in front of, Justice Jobber, even though I've known him since I was like 4? So they don't like to take them. There were 2 cases that originated in workers' compensation situations. So I thought I'd bring them to your attention. And again, it's a reminder, because we're doing it's not just one lane, it could be many lanes. So the first one I want to talk about is it was a horrible case. So I'm just going to tell you, I'm sorry, it was a horrible fact situation. Ms. Boyven worked operating a crane. And from what I can gather, she was at a large paper mill. From what I can gather, it was operated while you're standing on the floor of the facility, but it was a very large crane. One of them wasn't functioning. So her employer, the paper company, asked her to work closely with 2 employees who came down from Detroit, Maine, from the crane company that they work at. Unfortunately named Mr. Munster, asked Ms. Boyvert multiple times to allow him to get into the crane to see if he could figure out what was wrong with it. Wise Ms. Boyvert thought that was a wicked bad idea, but eventually he prevailed on her. She put him, he got into the crane, and then you can see where this is going. He stood up unexpectedly as she was raising the crane, got smushed on a big beam on the top, and then tumbled 30 feet, literally landing at her feet and passing away right there. So guess what? She has PTSD. No surprise, right? So obviously we all know she had her recourse against her own employer under workers' comp. Those are limited benefits. It's lost wages. I don't know that she'll ever be able to work again, certainly not in that industry, given what happened. So we got medical costs, probably years of therapy, and maybe permanent impairment, but she didn't lose a body part, so she won't have permanent impairment, but she'll have that medical and that indemnity. However, her attorney chose to sue the company that brought in the 2 crane operators. And it's a little vague. It basically was a dual theory kind of negligence or negligent infliction of emotional distress. It's Jim McAdam who brought the claim on her behalf, because obviously he had represented her against the paper company. I don't know if you guys know Jim McAdam, but he's a brilliant man, but he's basically Satan's spawn to some of us. Brilliant guy, but he didn't quite, from this fact pattern, it didn't look like he quite got it, but the end result was she was not awarded benefits because she couldn't make out the case for bodily harm, which you need under the negligence theory, and there was no duty of care, unfortunately, from those 2 employees from the other company to her. So she didn't win against the company that fixed the crane. Second one, another interesting fact pattern again. Guy didn't win. Sorry, it's not a winning year for employees who bring claims against other people than their employers. This fellow worked for a company that did food service at the University of Maine. And unfortunately, on this particular day, he was working on a mixer that did not have the appropriate size mixing bowl. it came dislodged or whatever, severely cut his finger. So obviously he has his action against his own employer and he pursues that. But then he sued the University of Maine system under what's known as the Tort Claims Act. I don't know if you guys are familiar with that, but it applies specifically to governmental entities. And it is what's known as a immunity centered act. So, but for a few little exceptions, governmental entities in the state of Maine are immune from suit. And so this guy tried under one of the this one exception, which is an exception if the injury happens with like a motorized. So the list was motorized vehicle, boat, snowmobile. I can't remember, but they're all were sort of motorized things. But then there's a catch-all at the end of this list of A, B, C, D, and that is and other machinery. And so he thought maybe this mixer would fall under other machinery. Ultimately, the law court interpreted, as I just mentioned, the Tort Claims Act to be one of immunity, and they didn't feel that a mixer was the same. Using a fancy Latin term, it's basically the same as the rest of the list. So he lost. So then moving to the appellate division, pretty busy year for them, 38 decisions. Brian Shabbat is a lovely, lovely human being, but he's a plaintiff attorney sitting as an administrative law judge. Let's just put that right out there. So it's not really a surprise that he was appealed the most. I think he's also newer in the role, so I think he's going to learn how to make it look like it's a fact, not an error of law, so that he doesn't get appealed, but that's just conjecture. I'm going to move over one more. These are the trends, but let me just give you kind of a little list. So the trends that I have been seeing are, and I just mentioned this at breakfast, because of COVID, a lot of employers are desperately seeking, it's not just COVID, I think it's COVID, I think it's the gig economy, and without sounding like an old fart, I think it's younger employees want better life balance and are looking for a different way of employment. But in any event, I'm seeing more very short-term employees suffering or alleging unwitnessed or maybe witnessed and not in the way that it's evolving through treatment kind of injuries, which that's getting to litigation. Just a disclaimer, you guys all know 99% of work-related injuries are just fine. You paid, they get back. We're trying to call it a recovery model instead of a disability model, and that's a big movement in the workers' comp world. So they recover. It's that 1% that has something a little weird about. Those are the only ones I see. Hence, I have a very, very black heart, but that's what I'm seeing. I'm seeing a lot more too, and this will be no surprise to anybody, but a lot more pre-existing chronic conditions being dragged in and being called gradual injuries. And I'm also seeing an acute and a gradual. That was a trick Jim McAdam came up with a couple of years ago, where he would have an old established acute injury, and then he'd come on back to the pot o' gold and start calling it gradual and see if he could get some more, sometimes successful. And that kind of speaks to another issue I saw as a trend in the appellate division decisions. There's a principle under the law, I'm going to use fancy Latin again, res judicata. It means the thing has been adjudicated or decided. And it basically means you can't come back over and over and come up with, use the same parties, the same injury, and try to get something else out of it. Unfortunately, I'm seeing activist administrative law judges making up ways to get around that rule. And that is a dire issue for employers because it means a claim is never done, right? I'm seeing employees who were found to have recovered in 2014, come back in 2019 and say, I've had changed medical circumstances because I'm going to tell you it hurts more. And the judge said, oh, that's changed medical circumstances. You would have no reason to pretend it hurt more. And say res judicata doesn't apply. So that's a bit of an issue. I'm also seeing more absentee issues. I'm not sure what's around that, but we'll have somebody who's having some attendance issues and then suddenly a work claim pops up. Now that's not brand new. I'm just seeing it trending as happening more. I'm seeing, let's see, efforts to avoid the caps on benefits. That's been going on for a long time. As you probably know, the first up to 2013, the level of permanent impairment, which is physical loss of function, in that context. It's not where you got to have the body part cut off and you get benefits for that period of time. So physical loss of function, if you were above a certain number of PI, you had the potential to receive indemnity benefits for the rest of your life. If you were below that level, your benefits were capped at, most recently it was 520 weeks. And a few things had to be proven. You had to be proven to have some work capacity, so you're only receiving partial benefits, and you have to be proven that you're below that PI cap. And then you file your petition to terminate benefits, and you file your petition to determine permanent impairment, and you hope you win. What is happening now that I'm seeing is folks going out to get additional surgeries many, many years after the last treatment happened because they're approaching the cap, which I worry about that because there's sometimes very ill-advised additional surgeries. And I'm also seeing a lot of cases where the employee is claiming not to be at maximum medical improvement, which is that term of art that when you can't assess permanent impairment if you're not yet at maximum medical improvement. And I saw a recent case from an ALJ where the only opinion in the evidence was that the employee was still going to have the same level of permanent impairment, even if they had that additional surgery they were threatening to avoid the cap. But the very, very clever attorney, who shall remain nameless, had put into evidence that the answer to that question. The doctor said, no, even if he has that surgery, he's still going to be at the same level of permanent impairment. So we'll see where that one goes. This was a huge one. I got like 3 minutes. Coordination of benefits, Social Security. Do you guys all know that when you have an injured worker who is receiving indemnity benefits, when they reach a retirement age, they're supposed to apply for Social Security or old age insurance. It only says apply for, by the way, in the act. It doesn't say receive. And that's very important because the case that I saw in the appellate division, the employee applied for and took 2 months of old age insurance. So predictably, the employer's insurance carrier, workers' comp carrier, began the process. It's called coordination of benefits. You get a 50% offset against whatever that amount of monthly old age insurance is coming. So if it's like, $500, you get a $250 offset for each week that you have to pay the workers' comp benefit. Well, then he decided to call, and I didn't even know you could do this. He contacted the Social Security Administration, said, hey, by the way, I'm going to wait till I'm 70 to take SSI, so stop paying me. What that triggers is at age 70, he will receive 132% of his benefit. At age 67, when he originally, his retirement age, he got whatever 100% of the benefit was. That's it. And the problem was they already coordinated benefits. They do not get to take advantage of the 132% figure. So the man's going to be getting a little bonus round in the old age insurance that is not offset against workers' comp, and there's nothing wrong with that. So just be careful and maybe have a conversation with your workers' comp carrier and make sure they're aware of that situation. The risk would be that you would delay a couple of months doing that coordination of benefits and getting the offset, but the bonus is maybe you get then, because you're smart, to take the 132%, 50% of the 132%, not 50% of the 100%. And then the final thing is coverage creep. There are a couple of decisions that were horrible that came out of the appellate division where essentially they're trying to make the workers' compensation system a 24/7 health, personal injury, everything coverage based on the fact patterns. And I'm not sure what we're going to do with that other than don't be shy, speak to the management members of our board, speak to your local legislators, let them know if these things might impact your workplace, because it's the only way right now we're going to kind of pull back on what I'm seeing as a very activist administrative law judge panel, very activist appellate panel, and a law court that hates workers' comp cases. So, and that's all. Does anybody have any questions for us? I came in a minute under.
Yeah, we nailed it.
All right, well,
thank you, everybody.
Okay, on my script, I'm supposed to introduce Doug and I. Well, first say thank you to Beth and Jeff because it was very informative, which it was, and I appreciate everything there. We're now turning it over to Doug and I for discrimination at work, implicit bias, microaggressions, and code switching. a good place to start with this topic is what is implicit bias? So many of you likely know, but I think I like starting again with definitions. Implicit bias is a form of bias that occurs automatically and unintentionally that nevertheless affects judgment, decisions, and behaviors. All of us have biases generally, but implicit bias are the ones that are harder to identify. Actually, we likely cannot identify them because they're implicit or unconscious bias. How, however, does that play a role or affect things that are going on in the work that we do every day in human resources, in operating our organizations? Choices that are affected by bias, and some of it's going to be explicit, some of it's implicit. It's going to include things like hiring, firing, promotions, job assignments, pay. I think if we go back to that Fifth Circuit decision I was talking about with Dallas County, why were women not allowed to work on the weekends, to take time off on the weekends, but men were? I think some form of bias was in play there, whether or not implicit or explicit. I think it comes out explicit, but they could have been couched in implicit concerns as well. Remember that when we're talking about implicit bias, we're not only talking about bias against people who are unlike ourselves, but we also can have what's known as in-group bias, or bias against people who may be similar in traits or characteristics as the ones that we hold. That's the interesting aspect about implicit bias, is it's not only out-group bias, but also kind of aspects of ourselves. Now, there's also two different categories or ways in which we talk about how bias implicates work. First, individual effects. The effects that implicit bias has on the choices I make are going to be different than the choices that Doug makes. That could be based off of our lived experiences or other aspects of just ourself. There's also, however, systematic and systemic issues that, from a cultural standpoint, whether or not that's as Americans, whether or not it's as individuals who live in the state of Maine, kind of larger system biases that play a role. One of the things that was mentioned recently was that idea or concept of, are you a Mainer or are you from away? Right? That's more of a systemic kind of dialogue that we hear people say a lot, and that isn't healthy. But with that foundation, I want to turn it over to Doug to have a dialogue about how this truly implicates the work that is being done in litigation.
Thank you. Is this working?
Not yet.
Is it working now? It is. Can I borrow you for this presentation? You're not going to hold it against me? Okay, great. Would you state your name and your employer for the record?
Denise Bignault and R.M. Davis.
Okay, Denise and I actually, by way of full disclosure, work together on the board of the Center for Grieving Children. So we know each other in that capacity. And I hope that you will still speak with me after this little exercise.
I do.
So what's your position title there?
VP of HR.
VP of HR. And so as a VP of HR, do you make it a point to familiarize yourself with the legal obligations that employers have with respect to their employees?
Yes.
And do you take your job seriously?
Yes.
Do you think you're good at your job?
Yes.
Committed to your job, making sure your employees are treated well?
Yes.
And so my question to you is, R.M. Davis has policies prohibiting discrimination.
Yes.
And those policies are intended also to prohibit harassment, bullying, and just any general mistreatment of employees based on their personal characteristics.
Yes.
And those are important policies, right?
Yes.
Something you care about very strongly. Yeah, very serious, but this is a serious issue, right? And we want to make sure our employees are well taken care of. Are you familiar with the concept of implicit bias?
Yes.
Okay, and so you've made a point, because you take your job seriously and you're good at your job, and this is, I think you testify, these policies prohibiting discrimination are very important to the organization. Make yourself aware of implicit bias and the dangers it presents to the possible mistreatment of your employees.
Yes.
Can lead to discrimination, right? So my question is, when you have two employees who receive a recommendation, or multiple employees receive recommendations for pay increases and they vary, what is it that you do to make sure that those decisions are not impacted by implicit bias? Or let's say it's an employment bonus. Bonuses are awarded, they're different in amount. What is it that you do to make sure that implicit bias somehow hasn't affected that decision? Or let's say it's with respect to hiring, or let's say promotions. What is it that you do? What do you actually do to make sure that implicit bias is not infecting those decisions? You don't have to answer. So in my mind reading mind, I'm thinking most of you are like, I do not like the idea of being on the stand in federal district court being asked that very question. But now what you have to understand is that as plaintiff lawyers' approach to litigation has evolved, that is now more and more going to be the focus of litigation. And so you've all gone through implicit bias training. You're all aware of it, but this is really, as Tony alluded to, trying to understand what does this really mean when we get involved in a case of litigation. Now, Liz over there was in many ways the lead lawyer in defending an employer for the past 2 years charged with race discrimination. And I helped out where I could. Long and short of it is we had to take the case to a jury trial in November. And one of the allegations was that this employee was discriminated based on their race, and it was a function of implicit bias on behalf of not only the supervisor, but the company as a whole. I don't know if you know, but at the same time, just shortly before that, there was a jury trial. Case was brought against Northern Lights Eastern Maine Medical Center, where essentially the same allegation was made, that because of implicit bias, the employee was a victim of race discrimination. Does anyone know the results of the EMMC case? It was in the paper. The verdict was $3 million. All right, $3 million based on the idea that sort of unconscious bias resulted in this employee being discriminated against and damaged because, as I said, because of this unconscious bias. I'm happy to report in our case, the jury came back in our favor and found that there was no race discrimination. But, oops, that didn't work. That worked. There, good. This document right here is the actual jury instructions from our case. All right, this is what the jury was told to consider. Basically said that the plaintiff may prove unlawful discrimination by demonstrating an adverse action, firing or denial of a bonus, was partly caused, not fully caused, partly caused by conscious racial bias or because of stereotypes or other forms of less conscious racial bias. That is, unlawful discrimination may be based on conscious bias, unthinking stereotyping, or unconscious bias. That's what the jury was told. You can find that this employer discriminated against this person, not even realizing that they were doing it. And it says you may, but are not required to infer discriminatory motive or bias as a matter of reason and common sense from the existence of other evidence, including circumstantial evidence, but you may not base your decision on speculation or conjecture. So what this means is that juries are now being told explicitly that you don't actually have to find a smoking gun. You don't actually have to find there was a conscious decision to discriminate against someone. It's sufficient for you to think that because someone has an unconscious bias, implicit bias, which all of you received training in most likely, that resulted in part of the reason why the person was treated the way they were treated. That should be, really alarming to all of us, because it gives sort of a jury an open invitation to find against the employer if they just don't like the way the employee was being treated. So what do we see in cases that plaintiffs' lawyers are using to establish that there is unconscious bias that affected the decision? And let me just back up to say, as far as I'm aware, this is the only 2 cases in Maine that happened essentially in the fall of 2022, where the jury was given an instruction about unconscious bias. And it was pressed by David Weber in the first case, who argued that it should be included because it's been part of a national trend. And so we're going to see more and more of that. And based on the precedent of these 2 cases, we think more and more judges are going to agree to include the unconscious bias jury instruction. All right, so what evidence do they say supports a finding of unconscious bias? And we know the answer because both cases involve summary judgment motions in which the plaintiffs were saying, Your Honor, deny the request to have this case dismissed based on summary judgment because we think this evidence supports a potential finding of discrimination, and therefore the case should go to the jury. The first thing is the makeup of the workforce. That if you have a workforce that is predominantly white, so says the federal judge, that is one factor that can be considered by a jury to decide that unconscious bias might be at play. Secondly, policies and trainings. To the extent that an employer doesn't have policies that really address the concept of diversity, quality, and inclusion, and or they don't do training that educates their managers and their employees on these concepts, that's another thing you can look at to reach the conclusion that even if it wasn't a conscious decision, there was subconscious bias at play. Hiring, firing, and promotion history. Is the person who's accused of the wrongdoing, do they have a history of hiring a broad range of diverse candidates, or do they only typically hire those who are white? Same with promotion, same with firing. You know, to the extent you have someone who, as a supervisor, never hires anyone who's a person of color, that could be used, says the court, is just one little piece of the puzzle as to whether or not unconscious bias might be at play. Response to complaints. If you have someone who complains about being a victim of discrimination or harassment, how the employer responds to that, if they are not fulfilling their responsibility to promptly and thoroughly investigate the matter, then that could be, again, says the court, used as evidence of unconscious bias. So even though you're talking about some complaint that was made by another employee a year ago, how the supervisor dealt with it can be used to say that that supervisor in making a decision with respect to this employee now was somehow evidence that they have an unconscious discriminatory bias. The fifth thing is differences in treatment. You give different bonuses, you give different pay raises, you hire one person, you don't hire another person. You give someone job opportunity, you don't give to the other person. What are the explanations? And if there aren't very good explanations, that could be used as unconscious bias. Again, we're not talking about whether or not for John, I terminated his employment because of race. We're talking about whether or not for these other employees, did I favor the white employees over the black employees, which then can be used as evidence of unconscious bias in how I treated John in my termination decision. The nature and tone of communications. In the Eastern Maine Medical Center case, the judge found as one of the reasons to deny summary judgment the fact that there was testimony by the plaintiff that when the supervisor was providing a performance evaluation and indicating in the performance evaluation there were areas that needed improvement, the testimony from the plaintiff was that the supervisor's means of communication, tone of communication was harsh. You know, it just felt, you know, like the really supervisor had it out for me and was really sort of, you know, irritated or angry in the way that the supervisor communicated with me. And that, said the judge, if the jury chooses to believe that, can be evidence of unconscious bias, reflective that race may have played a part in the decision to terminate the person's employment. And then the other thing is, last element is other various comments and interactions. So if supervisor makes a joke that's, racial in nature 2 years ago, that could be used as evidence of how there may be a bias there that affected the termination decision down the road. And to just flush that out, does it matter that you have friends who are Black? In our case, the plaintiff testified that 3 years before the events that sort of were the focus of the case, the supervisor said to him, I have these friends who are in a band. It's a great band. Oh, and oh, by the way, one of them is Black. That was what he testified to on the stand. And his point was, and he actually did a really nice job with this, was to say, I was really offended by that. Because why is it relevant that you have a friend in the band who's Black? I mean, you wouldn't bother telling me you have friends in the band who are white. Why are you even telling me that? And my feeling is it's just as a reminder of, oh, he views me differently. The color of my skin in my mind shouldn't be relevant. I don't even think about it as, I try not to think about it as being relevant at work. And you just told me it is relevant, that somehow it's in your mind, it's in there somewhere. It's in, it's affecting how you're thinking about me. And sure enough, the plaintiff's counsel in closing arguments try to use that to say, this is implicit bias, guys. The fact that he's talking about a friend who's Black is evidence that race is in there, and it's infecting how the supervisor is thinking about my client. Can we agree nothing needs to be done about this at this time? In this case, how many of you have gone through the harassment training where we've talked about if someone comes to you and says, I don't want you to do anything about it, but I think you should know. And then we're like, yeah, you can't just say, oh, all right, you don't want me to do anything about it, I won't do anything about it. And the reason being, we say that even if this person's okay with it, if we now know that the employee is engaged in this type of behavior potentially, we got to figure that out because it might be impacting other people. And if someone else sues down the road, the question will be asked, did you know that this, or had anyone ever reported this person engaging in this behavior before? And if the answer is yes, and then they'll say, well, what did you do about it? If you say, well, the person who told us said, we don't want you to do anything about it, so I didn't do anything about it. And you can imagine the follow-up is, you mean you knew about this, didn't do anything, and therefore my client experienced this behavior? But the other issue is, you never know when that person who says, don't worry about it, you don't need to do anything about it, will later on sue you and say, I never said that, which is exactly what happened in our case. The plaintiff had reported that two other employees who we didn't know who they were had talked about a show that had racial implications, and he didn't know, but felt that they were making a comparison with a character in the show to him. And he told his supervisor, and his supervisor said, write it up. He wrote it up, and then he said, all right, I can take it to HR. And the plaintiff said, well, I don't really want you to do anything about it. I don't even know who they are, actually. I think we can, just put it on hold. And if anything else happens, I'll let you know. And the supervisor says, fine. So that's what our client tells us. On stand, the plaintiff said, well, that never happened. I told him because I want him to deal with it. I found it really offensive. I was upset about it. Because I was upset about it, because I found it offensive, I went to my supervisor. I told him I expected him to go HR. He doesn't do it. Plaintiff's counsel, closing argument, says he complains about race discrimination and the supervisor didn't do anything about it. That, ladies and gentlemen, the jury, that's implicit bias. That's why we know that these things that were done to our client 2 years later, race was a factor. So you can see, hopefully, how this stuff really starts to play out in real litigation life. And as you as HR experts, and if the HR director from this client was present, she would tell you this is real because it happened to her, will be asked these questions in deposition, and depending on how well it goes in deposition, likely in trial as well. First question is, do you know what implicit bias is? And the plaintiff's attorney may ask you to define it to see how articulate you can be. The second question will be, what do you do to minimize the risk of implicit bias infecting decisions that are being made by your supervisors? You should take a moment right now and think, do we have an answer for that we would feel comfortable sharing as we're defending a lawsuit? And the third one is sort of what I did with Denise, and this was specifically asked of the HR director on the stand. When you see differences in pay and bonuses awards, what steps do you take to make sure they're not a function of implicit bias? So everyone in this room really needs to know and be thinking in terms of, how am I going to answer these questions? Because as lawsuits go forward, I think more and more likely you're going to find that's the case. So what do we do to limit the effect of implicit bias has on workplace discrimination and to help us minimize the risk of liability? And we've come up with 7 points. The first is to have meaningful DEI policies and a commitment from the top. And I want to emphasize commitment from the top. You know, you have to have the CEO at the training. You have to have the CEO introducing the training. You have to have the CEO really understand it and believe in those concepts. Because they're going to say, look, you know, they talk about DEI, they talk about how much they care about it, but the CEO couldn't even be bothered to go to the training because they're not really serious about this. And managers need to model appropriate behavior. I can't emphasize that enough. You know, they can't be doing any of the things that, you know, sort of we know they're not supposed to do and run contrary to that. And that's not only because we don't want managers engaging in behavior that might lead to claims, but because when they see managers behaving a certain way, the employees themselves will have a better understanding that that's what they need to do as well. And obviously you can imagine if they see managers not respecting those policies, they feel like it's a green light to behave in any way that they think is what they want to do. Education and training, the focus is on implicit bias. We talked about how there will definitely be questions in litigation about what it is you do. Who attends the training? Do you have proof that they attended? What happens if someone misses it? How do you catch up with them? Those types of things. Develop strong managers and mentors. Part of that is all of us trying to understand what biases exist and which may be some that we have. Be self-aware. And so really all of us as managers should do a gut check when we're making decisions to say, am I confident that, you know, if this person was male or female as opposed to being female or male or black or not black, would I be making the same decision? Am I following the same process I would for anyone else? Make an intentional effort to check and whether or not unconscious bias might be part of your decision-making thinking. Create a safe space for workers to communicate. Why is it that when someone is the victim of bad behavior at work, they don't raise a concern? We all know that one obvious answer is the fear of being retaliated against. There's also the fear of being belittled, being mocked. There's the fear of not being believed. You know, you become a victim twice over. You experience this behavior, you raise it, and then people are like, well, I don't believe you. I mean, talk about just a sort of a double whammy. But the other one that I think is really important to recognize is that, and I had someone at a training articulate this really well, and what this person said was, look, I get it. I know that this company is committed to treating employees well, that they're serious about enforcing their policies, that they won't, you know, take a hard stance against discrimination or harassment, and they won't retaliate against me. I know that they'll believe me. I know they won't belittle me. I get it. But I just don't want to be that person. You know, I just want to be able to come to work and do my job and not being, you know, the person who reported harassment. I don't want that spotlight on me. I don't want the idea that, you know, people think of me differently because I had this experience and or that I spoke up about it. I just don't want that. And so I got to be honest, if I'm subjected to this type of behavior, I'm not sure I'd say anything. And so the real challenge for employers, I think, is how do you combat that? How do you get to a place where someone's like, you know what, I feel comfortable and safe bringing this up, and I know that people aren't going to think of me differently. And I think a big part of that is getting to the point where we can normalize conversations about this type of stuff so that You know, if someone says, hey, wait a second, we had this training and those types of jokes, they're not good. Everyone else like, oh yeah, that's right. You know, and it's not a big deal and people aren't, you know, super defensive about it. And it's just, we have these conversations and it's just, you know, we're on the same team doing the same thing and we get it. And so you need to give some thought to how to get to that point where we've normalized those conversations. Next thing is to, I think, conduct secondary reviews of evaluations, pay awards, hiring, promotion, and termination decisions. And as part of that, really be thoughtful about whether or not there's any possibility that there's some sort of unconscious bias that infects things, you know? And so, for example, we had the HR director, I mean, it wasn't like we, spoon fed her the information. I mean, she was prepared to basically say, look, you know, when we have bonus awards, we take a look at those. We don't just accept them and we ask the question, okay, why are there differences in the bonuses awards? And we don't necessarily go immediately to, oh, is it because someone's sexual orientation or someone's color of their skin? But we ask the question of, you know, what is the justification? Is it supported in the evaluation? Is it the same experience that others have with this particular individual such that they deserve a larger bonus? Because we want to make sure that, you know, the bonus awards are fair, because one, we want people to be treated fairly, and two, it can be really demotivating for someone not to get a good bonus if they certainly deserve one. And if they don't get a good bonus, we want them to understand why. The other thing is to disrupt sort of our normal thinking by being intentionally inclusive. And that's almost sort of an affirmative action concept of looking for ways to promote diversity, to provide additional opportunities, professional development, and things like that. And then finally, to seek out information from employees to get a sense of how they feel things are going. That can be done by staff surveys. A new thing, well, not new, probably a lot of you already do it, is the idea of stay interviews. Is we're all familiar with exit interviews. When someone's leaving, we sit them down and say, hey, why are you leaving? You know, how do we do? But now more and more employers are like, well, why are we waiting till they're going? Why don't we, you know, talk to them before they leave and say, hey, you know, how are we doing? You know, what can we do better? How are you feeling? Do you think we're, you know, living up to our values and our culture as we, you know, represented in our communications with you and our handbook and the like. So now it's over to Tawny.
Actually, I'm going to ask you to go back one slide, Doug, if you would. As it relates to, see that last bullet about seeking out information. Earlier, you know, I gave you the example of the Fifth Circuit issue in Dallas County. There's a similar issue that happened 3 years ago in Illinois, where there was an argument made by a group of Black police officers that they were being placed in locations that were higher risk. So when they were put out on patrol, they were asked to patrol areas that had a higher rate of crime or were higher risk. They argued that this was because of their race, and they lost because the court found the location in which you patrol is not an ultimate employment decision, right? So Illinois has that same standard as what we see in Texas. So when we're talking about seek out information, there's also going to be a much larger dialogue with your operations team about, explain to me why you want to move this person to this position. Is there sufficient upward mobility in this position? Is this position one that employees are less likely to be excited by because it is a harder job, because it's more difficult, you know, a whole host of different things. In a healthcare industry, one of the things we see a lot of is, I don't like to work on this wing because the job is that much more taxing or difficult, even though another wing has the same number of patients. It's just a different type of patient subset, right? Those questions about operational decisions are going to be key when you are pushing back on your managers about decisions that they are making, because their unconscious bias is going to affect it more generally, in the same way, kind of me describing like, okay, we put police officers in a different district. Why? Is that similar to other districts? Are we doing it based off of some unconscious bias against the individual? Okay. Okay, so now we want to switch a little bit, but it's not a massive switch because we're going to talk about microaggressions, and then we are going to also weave into our discussion generally code switching dialogue. And these are two aspects that we're going to see more of when we are talking about implicit bias and how it plays a role in litigation. So, a microaggression, again, we're doing definitions to start it right off, is a statement, action, or incident regarded as an instance of indirect, subtle, or unintentional discrimination against members of a marginalized group, such as a racial or ethnic minority. Now, throughout the course of these slides, I'm going to use the term minority. I understand that there is a trend to move towards the language of new majority. Of course, the law has not picked up on that. So for right now, we're going to use minority. So that's what a microaggression is. We have given you an example of a microaggression already today. Can anyone identify what that was? Doug, what was the microaggression that we have already shared?
It's basically the supervisor saying, you know, just so you know, I have a good friend who's Black.
So we find that the best way to have a dialogue about what microaggressions are and how it affects claims of discrimination or implicit bias is to give some examples. And here's a whole host. I understand that the type is really small, but a lot of information that I want to throw in there, right? Here's one. I didn't realize you were Jewish, okay? Let's say that the topic ends there. I feel like when we say you don't look Jewish, okay, we're getting into issues where we've got some national origin, some religious discrimination, but what about just the term, I didn't realize you were Jewish? Okay, it's a microaggression. How many times has someone come to you and said, oh, I didn't realize you were Christian? It just doesn't happen, okay? It's not language that we hear regularly. Instead, it's signaling that the person of a Jewish heritage has some stereotype, either look or some other expectation I would have had, so I would have known initially that you, in fact, are Jewish. Your English is so good. Where are your parents from? Oftentimes, this is used when we have an employee who English is a second language, and it's signaling that people may be less capable of speaking English. So we often see that tied with national origin discrimination. How did you get into that school? Okay, this may not fall within a protected classification, but it's another form of a microaggression. It signals that someone's background, either where they're from, their socioeconomic condition, is such that it's an anomaly that they would find themselves at such a prestigious institution. Okay, so another form of discrimination, maybe not protected by the law, but a microaggression that you still should be aware of. Statements such as, that's insane, or isn't that crazy? Okay, another microaggression that adversely treats individuals who have mental health conditions. So a form of disability discrimination potentially. Statements such as, don't mind that, that's just my OCD. Oh, my OCD wouldn't let that keep going. In most situations, when you hear someone say that, they likely are not diagnosed with OCD. They're using the language in a way to say like, oh, I'm very neat and tidy and things have to be orderly. The problem with that is it's a microaggression against individuals who actually do suffer from OCD. Similar to, oh, my anxiety is acting up, right? That's different from, oh, I'm feeling anxious versus having anxiety or depression. So another form of disability discrimination. The statement, don't be so sensitive. Oftentimes we see that directed at individuals who identify as female. So we see a form of gender discrimination. Now, the too emotional isn't always happening, but oftentimes it's not something that's said to a man, it's a more objective classification. And then the question, oh, do you have a husband or do you have a wife? And questions such as that assume heteronormative culture and behaviors as opposed to, do you have a partner? I would be shocked if there's one person in this room who hasn't heard somebody in the work environment make one of these statements, okay? It is normal. It is something that we hear all the time, but it is something we need to push back on, okay? Because it is not healthy. It does not create a diverse and inclusive environment. And it, not only that, so like I can talk big picture culture, but Doug just spent a lot of time about talking about why my touchy-feely culture aspects have significant liability moving forward from a legal standpoint. And we can put a number on it. We can put a $3 million price tag on some of these things. Okay, that's something I need you to bring back to your senior leaders to have this dialogue about. It's unsurprising, but Tawny can come up with additional common microaggressions. So when I look at you, I don't see color. My best friend is gay, or I dated a Black man. Everyone can succeed in America if they just work hard enough. All of these are other common microaggressions that we see very regularly. So Tawny, don't just identify a problem, but help us solve it. I'm so glad you asked. Education, exactly what you're doing here today. Thank you for being here, right? Both because we appreciate seeing you, spending time with you, working with you, but also because it's our hope that this helps to limit your liability more generally, and also helps you to create a happier and healthier place for your employees to work. Correction. This is tough. This is such a difficult thing to correct, right? And I want to focus in on two ways that we can correct it. Both the correction of others when they exhibit a microaggression, and correction of ourselves when we exhibit one. So when we're correcting others, statements such as, let's make sure we're using everyone's correct pronouns when someone has used the incorrect pronoun when referencing or talking with a colleague. If you are unable to do it in that moment, going to the person and softly, and I try to use a non-attack format here. I know you didn't mean it this way, but when you use language such as insert microaggression that was used, that comes off as derogatory, as sexist, as whatever it may come off on. That's a hard conversation to have without having the person feel as though you're name calling or otherwise attacking them. But helping to identify and make sure individuals are changing their language is really important. What happens when we slip up? Because that is going to happen. We are going to misspeak. You likely heard, as I was just about to go to the last slide, I said, it's crazy, but I have another slide, right? Well, Tawny, you just said saying crazy is a microaggression, so let's take that out of our vocabulary. If I had in fact said that, if it had come all the way out of my mouth, what would I have said? There's two things, and unfortunately, we are trying to figure out the best way to move forward, right? So if I misgender or use the incorrect pronoun in the moment, I apologize. I realize I should have said their work and not her work. If the statement I just realized that the statement I made was inappropriate, I will work to correct this in the future, okay? Take ownership of what you are going to do moving forward. Something to the effect of, I will work to do better. Thank you for bringing this to my attention would be the way to respond when someone brings a microaggression to your attention. Maybe it's one that you made that you didn't catch. Saying you'll work to do better and thanking the person. Now there's a split in authority from people who focus in on DEI initiatives and general interpersonal and sociological studies significantly more than anything that we do here at Veril. And the question of, do you apologize, becomes really important. I'm sorry that I just used the incorrect pronoun with you. The reason why we question whether or not an apology is appropriate is because most often the individual who is on the receiving end of that microaggression is going to downplay the offense that they experienced as a result of it. And they'll say something to the effect of, oh, it's okay, no problem. it is a problem. It's not okay. That person likely doesn't feel great about it, but they feel as though you've put the onus on them to accept your apology and move on. So instead, taking ownership and attempting to do better in the future and committing yourself to do better in the future, it is a better practice. We've got 5 minutes and I'm going to introduce a whole new topic. And you guys are like, slow down, Tawny. Code switching. Code switching is the practice of alternating between 2 or more languages or varieties of language in conversation. This is a really important concept as it relates to inclusivity and asking our employees to bring their whole or authentic self to work. And remember, when we're asking employees to bring their authentic self to work, in large part, they're taking down a guard. We're asking them to be open. So if they then come into work, bringing their authentic self, and then start experiencing microaggressions, do you have an inclusive workplace? Most likely, no. Why do we find individuals code switching specifically at work? Oftentimes, reports show that people may code switch in order to not adapt or not act with regards to a specific stereotype. So one of the examples we hear often is individuals of Asian descent who refuse to do math or do not do math problems, don't work in accounting because they fear that their national origin has a stereotype that they're good with math and numbers. Okay, so instead, an individual is not going to do work of that type for fear of conforming with that stereotype. In certain situations, there may be code switching in order to achieve specific results, to fit in with the culture of the organization in order to get a job done. You likely know in order to get a job done with this person, you have to take them out for 2 beers, talk about the Eagles. I was on a call the other day where we spent 10 minutes talking about the Eagles. And I was like, no, I know. And then whether or not a quarterback, and I just went with it. I'm like, yeah, we're gonna do this. I didn't watch it. I read the highlights. Doug, I don't know. Did you watch it? We got some quarterback issues going along. You can't do the running
I
game
watched
the
the
whole
second
time.
half, but I'm sure too much detail. But anyway.
Yeah, no, it was tough, right? But in that moment, I had to code switch and say, oh yeah, those Eagles, those Philly fans, oh my gosh, right? Like go through the whole thing to be like, I just need this guy to move on and give me authority to settle this case. But in most cases, when we're looking to be our authentic self at work, this code switching isn't going to be helpful. And creating a culture in which people feel as though they need to code switch in order to fit in order to get what they need, it's not going to be healthy. Some individuals, however, will identify that they've been code switching since grade school, since all of their schooling, right? This is something that just is who they are, and it's the only way that they can express intention. And at this point, it's unintentional. Our goal would be is that the more we focus on being your authentic self at work, that people will be able to go back to kind of the person who they are when they're with friends and family, while understanding the parameters of information you share and don't share at work. How, however, can we decrease employees choosing to code switch at work? Employee resource groups is one great way. A big thing, though, that you need to keep at top of mind is that they need to be effectively set up to avoid liability. Some of you may have seen the recent article in the Portland Press Herald concerning the complaint that's been filed with the Department of Education against Portland Public Schools concerning their BIPOC community circle. One of the reasons why that is being brought to the Department of Education's attention is because there's a very specific term within that community circle that says participation is not open to all, it's only open to individuals of color. In a ERG group or any other type of affinity program, making sure that it is open to people who are supporters of that new majority or minority group is really important. having diverse leaders. And when we talk about diversity, remember, we're talking about it in all aspects, not just those that are protected by the law. Diluting the dominant culture. There are so many ways that we can do this, not just through the hiring and retention and promotion programs in which we institute, but also consider the vendors that you're using. Consider the art that you hang on the walls. All of those are important. And then finally, education. You're all sitting here, kudos, thank you, but that's going to be an important aspect. I think we have 1 minute. I know that Doug set forth a lot of stuff, especially regarding litigation and what we see in the future. Any questions, concerns, anything along those lines that people have?
Or do you want to get on with your day?
Well, thank you so very much. We have very much appreciated seeing everyone today, and we wish you safe travels wherever you're going. A brief reminder that we have CLE and SHRM certificates that are printed out in the lobby. And also we'd ask you to complete a brief survey, which helps us to understand what your needs are in programming that we can create that will help everyone in the future. All the attorneys will be sticking around. So if you do have questions or comments that you want to discuss, please feel free to speak to any of us. Have a wonderful day.
Like everyone's staying to take notes.
This mic is turned off. I'll take care of it.
Okay.
And I'll go in the closet, grab your dongle for your
I told her to be right.